with what we have built as the engagement with media influencers, opinion leaders, but essentially the agenda setters in our media space, the ones who mediate some of our most important public conversations. We thought it would be important as part of this process to engage that community, and I'll explain to you why it is that we think we should have a separate engagement with all of you. So we are in our third month of our public engagements as a committee. We have so far held a series of thematic stakeholder engagements covering about 12 broad themes. We have covered a wide range of issues ranging from lands and natural resources to public services to anti-corruption to rights, gender, youth, political parties, the public services and public enterprises, the judiciary, legislature, executive, and the like, all under our thematic engagements. We have also held a number of engagements with what we call identifiable interest groups. These would be the military, the police and security services, academia and professional bodies, the business community and organized labor. And I would say this engagement is actually fits under that category of identifiable interest groups, because it's not, even though most of you are from the media, we don't consider this an engagement about just media, because your interests are cross-cutting and cross-thematic, so we expect to have a much broader engagement beyond the concerns or interests of the industry or the profession as such. Then we have also held a third category of stakeholder engagements with those we have described as eminent persons. These are individuals who have held high office within our constitutional system, whether as presidents, vice presidents, chief justices, and in other such roles, including people like Dr. S.K.B. Asante, who were instrumental in the making of the Constitution. So we have held all of these and continue to hold these meetings. Tomorrow we will be journeying to Peduasi to speak with former President J. Kufuor. So these are the kinds of conversations we have been having since March. And once we're done with these very selected engagements, we will then have the broader public engagements in 12 different locations across the country, as well as with the diaspora online in what we call the zonal engagements. So the country is divided into 8 zones in 12 locations, and we will travel around the country to have those conversations. Then that would wrap up our public engagements, and then the committee will then retreat into conclave, so to speak, and start our deliberations and report writing. So today we are glad to have you here for this conversation. Some of you have participated in some of our thematic engagements and also in some of our earlier stakeholder meetings. But today it's on the media, not as an industry, but media personalities, media voices, influencers, I don't know the appropriate name, but these are opinion leaders and those who help us filter through and mediate the conversation in the public square. We believe that you have exceptional insights to offer on this process, and that is why we have extended a special welcome to you to join us today. So the idea is, one, of course, since you're here, we will get to talk about the media, about the profession. People are interested in issues of media regulation, media ownership, and those other issues. But beyond that, we also would like to have your perspectives on a whole range of issues that on your mind, as well as, you are quite much closer to the public than we are. So what's on the public mind? What do people want? What is it that you think this country needs moving forward? So once again, welcome. My name is Kwesi Prempeh. I am the chair of the committee. I think we can start with my colleague, Ibrahim Tanko. He will introduce himself, and then we will go through a round of introductions by the committee. Then I think we will go around the table, and you can introduce yourselves too.
All right. Good morning. My name is Ibrahim Tanko Amidu, a member of the committee.
My name is Kwame Kakeri. I'm a member of the committee.
My name is Godwin Jokoto, a member of the committee.
I'm Justice Sophia Adenra, member of the committee.
So thank you. It's an 8-member committee, 5 of us making up a quorum, physically present. We will be joined in due course by the other members of the committee. So thank you for coming. As I said in my earlier remarks, this is a conversation about media, about your industry, its place in our constitutional system. There's a whole, chapter dedicated to your industry. There are other, you make an appearance initially in the chapter on Bill of Rights, but I think in recognition of the special nature of media, you also have a whole chapter dedicated to the media. There's a constitutional body established that is also dedicated specially to the media. We have provisions on state-owned media, about the only state-owned commercial bodies that actually find a place in the media in the Constitution. Other state-owned enterprises are not part of the public services chapter of the Constitution, but you are. So clearly there is, the Constitution attaches a great deal of significance to media and journalism, and so do we here on the committee. And we thought we would invite you so that you can assist the committee in the work that has been assigned us. So thank you for coming. Maybe we'll have you do a round of introductions around the table. From the last man there is a member of our secretariat, he's a researcher, so we can skip him and start from those of you who are here for the first time and coming from the media. Thank you.
Thank you. My name is Dominic Mloji. I'm the National Organizing Secretary of the Ghana Journalists Association. Ghana Journalists Association. Yeah, and I also work with the Ghana Broadcasting Corporation.
Thank you very much, Prof. Chair. My name is Kofi Yeboah. I'm the General Secretary of the Ghana Journalists Association.
Thank you, Chair. My name is Zakaria Tanko Musa. I'm a lecturer at the Institute of Journalism, UNIMAC, and a member of GJA.
Thank you, Professor Chairman. Good morning, everyone. My name is Rebecca Ikpe. I'm representing here the Public Affairs Officer of the Ghana Journalists Association. I also work with the Ghana Broadcasting Corporation as an editor-in-chief. Thank you for the opportunity.
My name is Kweku Enchibuesiako. I'm project coordinator for the CRC.
My name is Kojo Yankson. I work for Joy FM.
My name is Kojo Akoto Boateng. I work with him at Joy FM.
I'm Suleiman Abrahima with the Media Foundation for West Africa.
Joanna Eskinataja, tenor auditor, GBC.
John Osei Korasari, Director of Human Resources, Ghana Broadcasting Corporation.
Thank you. Amin Al Hassan is my name. I'm the Director General of the Ghana Broadcasting Corporation. Thank you.
Okay. I'm David Kukuyagali. I work with Imani Africa.
Prince Kanaku, private legal practitioner.
Kemni Amano, Media General.
Ebenezer Anan, Ghana News Agency.
Antoinette Boama, private legal practitioner.
Derek Aka Nyameke, State Attorney at the Office of the Attorney General.
Techi Edua Mankwa, I'm a researcher for the CRC.
Aretha Bamford, Legal Research Assistant.
Heba Abdel Nasser Mukhtar, Research Assistant CRC.
Patience Asabagna, Legal Research Assistant CRC.
Okay. So thank you very much. Usually, the way we proceed, when we're having thematic conversations, we usually have an opening presentation by one of the participants. We call it the anchor presentation that essentially paints the broad picture, flags a number of issues under that particular theme, and then that helps to organize the conversation for the day. But because this is, we see this more as cross-thematic, we are not looking forward to any single overview of the topic. We do know that there are important questions around the media. Yeah, no. Yeah, so there'll be a presentation by the. So there'll be a presentation by the GBC. Yeah, so a number of the issues we have encountered here that, of course, are of special interest to the media have to do with the National Media Commission. When we considered the independent constitutional bodies, the NMC was with us, they were represented. So we have talked about media somewhat under that theme, and issues around the scope of the powers of the commission in terms of regulating the media space have come up. Some others have raised issues around media ownership and whether or not going forward we shouldn't take some look at the media space and look at questions of ownership, especially insofar as they relate to political party polarization and some of those issues. So these are some of the issues that have come up that I think specifically relate to the media. We have also had conversations around political party financing, campaign financing, which of course have something to do with the media as well, and the issues of state ownership and its participation in the media space. So we expect to have some of your ideas around those issues, but like as I indicated, once we're done with the media-specific issues, we are also counting on you to give us a broad, to step outside the media space and give us your thoughts on just the entire exercise. Particular themes, you know, it doesn't have to be about any issue, to the extent that it relates to governance and you think that this process can help either bring some light on that issue or help resolve a particular challenge. We invite you to share those with us. But we understand that there are two presentations, that one would be on state ownership of the media and some of the views on that. We know there's been some debate back and forth about that. So we will invite a presentation on that particular issue first, and then we will move on to the other issues. Thank you. I understand you will make that presentation, the Director General.
Yeah, thank you, Professor Chairman. And we, from the Ghana Broadcasting Corporation, are particularly happy to be given this opportunity to share our views. Basically, the position of the GBC is that we have had specific mention in the Constitution and subsequent Supreme Court interpretations of what the state-owned media means and what it should do. And there were certain expectations or certain assumptions that it will be in a particular form. So what this short presentation is simply to do is to present to you our experience in the last 3 decades, a little over 3 decades, what has been the outcome of that experience, and our projections, whether we will be able to survive the next 3 decades, based on what the Constitution has provided. And some of it is that our position is that the Constitution had a certain view about state ownership and certain assumptions, and the last 30 years or more has shown that most of them haven't been properly as expected. So quickly presented to you is a quick introduction and a justification for public service media. Now, when you look into the Constitution, the state-owned media, please go back too fast. The state-owned media had the expectation that the National Media Commission will insulate the state-owned media from governmental control, specifically Article 167C, that specifically says that it has the duty to insulate the state-owned media. And so subsequent Supreme Court rulings has meant that the NMC has to appoint the CEO and the board of these organizations. Now, after 3 decades, what have we experienced? And what must we ensure that these important institutions of democracy will survive for the next 3 decades? But the point to make, and the reason why the Constitution was specific about state-owned media, presumably, was the expectation that of all the media systems we have, it is only the public service media that has the mandate to ensure universality of access and diversity of content. No other media system has that mandate. And it was for this reason that the Constitution was specific by putting a certain amount of burden of responsibility on the state-owned media. And it was expected because if you look at across the world, from the United States to the United Kingdom, the European Union member states, Canada, Australia, Japan, and South Africa are just a few examples. But what we can say is this: throughout the world, all serious nation states have maintained a publicly funded public service system. And our example is the Ghana Broadcasting Corporation. But the basic idea is that it is not to be seen to go out there to do advertising to generate revenue, but it is to be seen to ensure that Ghanaians everywhere, which has to do with the universality of access concept and the diversity of content, Ghanaians everywhere must be given content whether there is advertising revenue or not. And that is why across the world, the type of GBC is always in there. But the character given to GBC in the Constitution is the problem. Next slide, please. So, for example, when you go to Article 55:11, the state shall provide fair opportunity to all political parties to present their program to the public by ensuring equal access to the state-owned media. The Supreme Court judgment on MPP versus GBC has interpreted this to mean equal airtime to all political parties. There was no provision for how the resources will be provided to ensure equal access. So GBC over the years has expected that the government will resource it to deliver. And we have seen a consistent refusal of government not to resource GBC to deliver on this particular mandate. And so the Constitution has properly insulated GBC from governmental control, but accidentally, it has also insulated GBC from the resource allocative power of the state. So our submission is that we must find a cure for the resource allocation for GBC. And I will show you further evidence to show that the last 25 years has seen a very sorry story of consistent denial of resources. It doesn't matter which party is in power. The assumption is that if they resource you to give equal airtime to all political parties, they are invariably giving resources to the other parties to contest. So any government in power finds it prudent not to, in their own selfish interest, to resource GBC. So that is exactly why over the years, in the last 25 years, consistently, GBC has had issues of equipment. So our point we are making is that the insulation from governmental control as contained in 167C has resulted in governments consistently not resourcing GBC to deliver on this mandate. It's a very fantastic clause, but it has a weakness that has to be cured. And we think that this committee should look into that. How do we ensure that GBC, even as it is insulated from governmental control, is not insulated from the resource allocation power of the state? Next. So we are saying that there's something missing in the Constitution, that to protect state-owned media from resource starvation. Two, for example, in the last 11 years, 700 staff of GBC have retired, resigned, or died, and have not been replaced. This is consistent, deliberate attempt to create a natural attrition that will lead to unsustainability of the Ghana Broadcasting Corporation. So our projection at management is that GBC, if this trend continues in the next 5 years, it will not be sustainable. The human resource levels will not be able to sustain it. And oftentimes, when we say this, people think GBC is GTV. No. Most of our resources are into rural radio broadcasting. We maintain 18 FM stations, broadcasting in 27 Ghanaian languages across the country. And that is where most of the work of GBC is. Not GTV or GBC News. No. The real work of GBC is in rural and across the board, FM station broadcast, radio broadcast. That's where we put most of our resources. Now, in the last 25 years, we have had no capital expenditure on GBC. So, for example, every good national broadcaster must have an OB van. We haven't had an OB van in 25 years. We have to rent it from the private sector at $15,000 a day if we must broadcast live broadcast for international audience. Across Africa, all public service broadcasters are given new OB vans by their government. GBC, the last OB van we have has a registration number X. Before we started numbering our cars with 2009 up to 25. So we think that the infrastructure deficit is set to collapse the organization until the cure is found. Next slide, please. So GBC has been denied funding for election coverage to honor its constitutional obligation as put in Article 55:11. That denial simply translates to mean that when it is time for election, we give very minimal airtime to meet our constitutional obligation and reserve a chunk of the airtime for the political parties that can buy. I don't want any lawyer to tell me that I'm breaking the constitution, but what I'll tell you is that I have electricity bills to pay, I have fuel to buy into vehicles to run. So to raise the money, we sell the airtime, and this is not really right. It has to be corrected. If the state provides the resources, we will stop selling airtime to political parties. We will grant as the Constitution has instructed. So we are saying, and we are putting before this committee, that there are two options. There are two options opened for your consideration. And one is to provide resource guarantees for GBC to ensure that it survives the next 3 decades. The second option we are putting before you is to say that GBC be properly set up as a public service broadcasting system. As a public service broadcasting system, which must be in the form as BBC, where their resources is not at the whim of government of the day. We must choose one of these options to pursue. Yes, next slide. So if we go for, and we have, Chairman, we have a set of 5 recommendations covering these two options. If we were to keep the state-owned media in its current form, we are requesting that we must provide a cure for the denial of resources. Next. 2, that if we keep the form as it is, that it should be state-owned media in its current form, then we are also requesting that we need a clear definition of what constitutes state-owned media. Mr. Chairman, there is a certain coincidence, I will call it. It might not be intended. At a time where certain state institutions are using public funds to set up TV stations, like the police TV, having better equipment than GBC, the question we put before the committee is to tell us, does the police TV qualify as state-owned media? In which case, it should be properly located within the National Media Commission. As we speak, it is not. Now, the definition of state-owned media has to be properly defined so that police TV, and we are expecting to see Fire TV and other state agencies are all clamoring to have TV stations. Should they have, which we are not begrudging them, but we are saying that we need a clear definition of what constitutes state, because if they are also state organizations and they are resourced to run TV stations, and we are denied the same state resources, then there must be a very canny and very interesting coincidence, which we are not able to tell exactly what is happening. But we think we should bring it to the table. We need a clear definition of what constitutes state-owned media. 3, should we go with the second option, which is GBC should be properly set up as a truly public service broadcasting organization? We are saying that there are global best practices which we can refer to, which we are requesting that let us go ahead and roll it out as a proper public service broadcasting system. And the BBC example is there for us to learn from. And we are also saying that in whichever form you take, whether we are going with the state-owned broadcasting or we are going with the public service broadcasting, there must be a clear compulsion on the state to fund election-related coverage of political parties. Because the Constitution, in its original form, did not mention GBC. It said the state. And a subsequent interpretation has meant the state means the state-owned program, like GBC. Fine, we are happy to take up that responsibility, but we say that there must be a clear compulsion on the state to fund GBC to do election-related coverage. And the last, Mr. Chairman, is to say that when this constitution was passed, and for most of the 32, 3 years we have experienced, GBC was tax exempt. In recent years, GBC has been told that we are no more tax exempt. And last year, we ordered 4 transmitters to do public service broadcasting. And these transmitters are deployed at Wa, Bolga, Kumasi, and Accra. And we were told to pay duty to customs. And we had to pay over 300,000 cedis. We think asking GBC to pay such a tax to do public service broadcasting is punitive. And we think that something should be done about it. Because for most of the period that this constitution has been enforced, GBC has been tax exempt. And I think in the last 3 or 4 years, they have imposed tax this on us. So, Chairman, I want to thank you very much for the opportunity to present this. And a formal comprehensive paper will be submitted to the committee. This is just to bring this up for discussion. And thank you very much for the audience.
Thank you very much, DG. This is one of the things that we have learned from this process is how very little progress we could have made on our own had we not gone the way that we have, which is engage different constituencies, different stakeholder groups, different parts of our community to understand their peculiar issues and their peculiar encounters with the Constitution and how it would shape our process. There's no way that we would have gotten any of this kind of insights in relation to state-owned media if we had not invited you here and if you had not accepted our invitation to come here today. So thank you very, very much. This has been quite insightful. And yes, we actually encourage written submissions from the participants who come before us to share the ideas with us. So we will hold you to your promise. And we also invite similar submissions from all of you here. Could be individual submissions, could be institutional, but definitely do use our channel, Constitution, submissions at constitutionreviewgh.org. And you should be able to talk to our staff and project coordinator here about sending the submission. So thank you very much. This has been exceedingly helpful. I understand there's a second presentation. Once that is done, then we can open the floor up for the committee will take some questions for the presenters, and then we will open it up for conversation with the general audience here. And be reminded that this is also being live streamed, so we have a public audience as well. Who is presenting next?
Thank you, Prof. Chair. Okay, yes, Prof. Chair. A small media coalition was put together just to solicit some views about the constitutional provisions that affect the media. And so we gathered some information from the media fraternity, and we have put that together, and we would also be making a very elaborate submission. But this brief presentation is just to highlight some of the key issues that have been extensively elaborated in the submission and some of the recommendations that we've made. But I have almost all my colleagues here, and they would be intermittently coming in when you posed the question. I hear you said you have questions for the presenters, but those questions would be answered by almost all our colleagues here because we've all made a few inputs here. Okay, next slide, please. So our presentation is just going to look at the current state of media freedom and look at the challenges and then the proposed amendments that we are proposing to strengthen the media landscape. Next. And we do recognize the importance of media freedom and independence. And I think observing the presentations that have been made, even when you look at others who came around, everybody realized that the media is very important because media freedom and independence are essential pillars of our democracy. They promote accountability, transparency, public discourse. And we all know that a free and independent media ensures that our citizens are informed and it enables them to make informed decisions. And we know that those things go by and large to affect almost every aspect of our society. Next slide, please. What is the current state of media freedom in Ghana? Ghana's constitution guarantees freedom of expression and the right to information and the media freedom and independence. And Prof. Chair, you indicated that a whole chapter has been dedicated to media freedom and independence in Ghana, and that's very unique. And it goes to show the importance of the media in our democratic architecture. And just to highlight a few of those provisions, Chapter 5, Article 21 of the 1992 Constitution, there are a number of provisions there that talks about all persons shall have the right to freedom of speech and expression, which shall include freedom of the press and other media. And it's very crucial because at the time that the framers of the Constitution put together the Constitution, the media landscape hasn't taken this sort of outlook. And now you have all sort of actors who are almost playing the role that the traditional media plays. And what role do you give them? How do you recognize them? Do they come under the safeguards that the traditional media come under? These are all things that, constitutional review would have to take into account to deal with those situations. Next slide, please. Freedom and independence of the media is guaranteed in Chapter 12 of the 1992 Constitution. And some of the key highlights, 162, freedom and responsibility of the media. Next slide. But, as practitioners and also citizens of Ghana, we hear that all the time, where when the issue of media freedom and independence comes up, people are under the impression that, are you saying that the media should be allowed to churn out all sorts of ideas, no matter how false, alarming, and dangerous they are, irrespective of what it is? Certainly not. That is not what the Media Coalition is saying. We recognize that, no, you cannot allow the media to just churn out everything they want to churn out under the guise of freedom of expression, media freedom. Yes, next slide. Because the Constitution itself recognizes that freedom is not absolute. And it's not only media freedom, but you would struggle to find any freedom in any democratic institution or any democratic country where freedom is absolute. There would always be some sort of qualifications. And Chapter 12, Article 164, does talk about the provisions of Article 162 and 163 of this Constitution are subject to laws that are reasonably required in the interest of national security, public order, public morality, and for the purpose of protecting the reputations, rights, and freedoms of other persons. And then it goes ahead in Chapter 12 again, Article 165, to talk about the fact that for the avoidance of doubt, the provisions of this chapter shall not be taken to limit the enjoyment of any of the fundamental human rights and freedoms guaranteed under Chapter 5 of this Constitution. And what is in Chapter 5? That is where almost all the fundamental human rights that have been guaranteed by the Constitution can be found. So there again, it's reminding us that, yes, in exercising your right as a media, you should be mindful of the fact that some other people have been guaranteed or given rights under Chapter 5, so you should be mindful of how you use that. So that also demonstrates to us that, yes, freedom is not absolute and that it is qualified. However, there are challenges, and these challenges are due to the vague and broad provisions of some of the articles in the constitutions that indirectly leads to some interpretations or some actions that interfere with the very concept of freedom and independence of the media. Yes, next slide. And just to tease out some of these examples that we talked about, Article 21:1, all persons shall have a right to, and then when you look at F, it says information subject to such qualifications and laws as are necessary in a democratic society. And this issue about subject to qualifications and laws as are necessary, the word necessary itself, all sorts of interpretations have been given to it, and it has led to all sorts of things that we would see in the preceding slides. 2 says, a restriction on a person's freedom of movement by his lawful detention shall not be held to be inconsistent with or in contravening of this article. Yes, next slide. For the imposition of restrictions that are reasonably required in the interest of defense, public safety, public health, or the running of essential services. There again, we see the use of the word reasonably required, and we see the use of public safety, public health coming in again. And then when you look at E, the word reasonably comes in again, says reasonably required for the purpose of safeguarding the people of Ghana against the teaching or propagation of a doctrine which exhibits or encourages disrespect for the nationhood of Ghana and national symbols and emblems, or incites hatred against other members of the community, except so far as those provisions or case may be, the thing done under the authority of the law is shown not to be reasonably justifiable in terms of the spirit of this constitution. So we see this word again coming up quite often in those provisions. Next slide, please. Article 164, there again we see the word reasonably, national security, public order, public morality, and then for the purpose of protecting the reputations, rights, and freedom of other persons. We've talked about 165 already in another, in the previous slides. So next slides. The consequences of such provisions is the justification of its use. So because of some of these provisions and the broad and vague way they have actually been couched in the Constitution, we see that some provisions in our statutory provisions, like the Criminal Offences Act of 1960, Act 29, where Section 208(1), that talks about when a person publishes or reproduces a statement, rumor, or report, which is likely to cause fear and alarm to the public or to disturb the public peace, knowing or having reason to believe that the statement, rumor, or report is false, commits a misdemeanor. And we are aware that in 2001, because of the international, protocols that says do not criminalize, media freedom and independence, we repealed the criminal libel. But for some reason, this provision is still in our book. And anytime this issue comes up and the media complains about it, we are taken back to the fact that, mind you, the Constitution itself has indicated that your freedom is not absolute, it is qualified. And these are one of the qualifications where we think we can throw in to deal with those sort of concerns that the framers of the Constitution had. Next slide, please. We have, now, if you go back, this provision, please go back one slide. The 1960 Act, when people raise this issue and say it is almost indirectly or another criminal libel in another form, they say, well, maybe when they repealed the criminal libel, they forgot about this provision. That's why it was not repealed. But then you go to the next slide. which was quite recent, 2008. And you look at the provisions in Section 76(1) of the Electronic Communications Act of 2008, it has almost a similar language and trying to achieve the same purpose as the 1960 Act. So it wasn't really an inadvertent provision. It was just left there for a purpose. But the purpose for which it was left there, the media by and large has suffered and continue to suffer based on these provisions. Next slide, please. Section 76(2) also talks about that same concerns that we have. Next slide, please. And false publications, is it at variance with international standards? These provisions that we see quite often that is being used against the media, a number of African countries, their courts have indicated that they are actually provisions that are in variance with international standards when you talk about the concept of freedom of the media and independence. In the Kenyan High Court, something in Zambia, even the ECOWAS Court had cause to raise concerns about some of these provisions. Next slide, please. And this is what we need to, we are concerned about, the use of national security concerns and fundamental human rights. This is frequently relied upon as a reason for justifying the interference with media freedom and independence, using these provisions in our statute, because they say the Constitution has made provisions that your freedom is not absolute, it's qualified, and it can be interfered with if it's in the public interest to do so, and all those things. And there is this particular concern that has been raised about the use of an amorphous concept of national security to justify invasive limitations on the enjoyment of human rights. It's a serious concern because, as we said, the concept is broadly defined and is vulnerable to manipulation by states as a means of justifying actions that target vulnerable groups such as human rights defenders and journalists and activists. And it also warrants often unnecessary secrecy around investigations or law enforcement activities, thereby undermining the very principles of transparency and accountability which the media almost always seeks to promote. Next slide, please. So these are the proposed constitutional amendments which has been extensively touched on in our submission that we'll be sending. We are proposing that we should strengthen protections for media freedom. And how do we strengthen those protections? We need to be very clear-cut in terms of some of the definitions so that we cure the broadness and vagueness in the constitutional provisions. Enhance media independence, establish clear and transparent guidelines for media regulations, and then promote transparency in media ownership. Next slide, please. And some of the recommendations that we are also making is that we'll see increasingly that the media has been in the forefront when it comes to exposing, wrongdoing, exposing issues about corruption in our society. And this is not done by just the mainstream media. By and large, it is done by going out of the normal media reportage. And investigative journalism is one of the tools that are used to do that. But investigative journalism is a very expensive, if you like, a venture. And so by and large, a lot of media houses are staying away from that. And so what happens is that you see that those media houses that are doing that under extreme financial constraints, or they get funding from external sources. We are saying that because of the insidious nature of corruption in our society and the role that investigative journalism can play to deal with that situation, we should consider establishing an investigative journalism fund so that fund, and we have provided an extensive framework of how that fund can be put in place, how it can be managed, the composition of those who can actually be managing that fund. And we are talking about this whole limitations on freedom of expression and media freedom. We should go back and evaluate the way those limitations are done. Are they done in a way to, if you like, achieve a legitimate aim? Because by and large, we realize that when those provisions under the constitutions are used to try and interfere with media freedom and independence, you realize that the aim is not to achieve a legitimate aim. They are more or less to achieve sometimes political interest, parochial interest, but because they are so vague, people rely on that to perpetuate this sort of interference against the media. And sometimes what we realize is that even when they are used to achieve a legitimate aim, they are very disproportionate. So you look at the provisions we talked about, Section 208, that has been used largely against the media. Most of the instances where the media personnel have been arrested, no prosecution takes place. They just arrest the media person because they said he or she has published something that has the tendency to cause fear and panic. He gets arrested or she gets arrested. She's taken to the police station. He or she is denied bail. And then after you go in there, after 2 days, they release the person and nothing happens. But that case is still pending. Just to warn you that in case anytime, you do something that they are not comfortable about, they remind you, hey, if you say, what case be ohana? And we're saying that this is not something that is healthy. And so we should find a way of actually defining these limitations and finding a way of providing very clear-cut guidelines and regulations to deal with that. And ensuring parliamentary approval, and I think Prof has mentioned that when it comes to the state-owned media, we are saying that looking at the role the state-owned media is playing, we're saying that their budgets, the way the budgets now is dealt with, I think it's dealt with through the ministry. We are saying that why can't their budget be dealt with like some of the statutory, organizations or institutions where they may directly go to Parliament and get their budgets, approved, so that sort of, formula where they have to go through the ministry, and we know that sometimes it has been used to indirectly deny them of the much needed resources and all those things. And then we're pushing that. We know that there is please go back a bit. The broadcasting bill has been in the pipeline for so many years, and nothing seems to be done about it. We hear that there is some attempt to make it happen, but we are saying that if we're going to push for this to be done, maybe we should have a provision in the Constitution where we give timelines. Say that after the amendment has been done, maybe within this period of time, the broadcasting bill should come into effect. That way, you make it very difficult for anybody to continue to extend or prolong the passage of the broadcasting bill. Yes, please. In conclusion, we are arguing that a vibrant and independent media is crucial for Ghana's democratic growth. Implementing these recommendations and proposed constitutional amendments will strengthen our media landscape, promote diverse narratives, and ensure that journalists, media professionals, and houses can order fair and positive growth. This would leave us with a vibrant and independent media, which is crucial for Ghana's democratic growth. And when we do that, by and large, we would also be strengthening other institutions that rely on the media to keep the limelight on the way they do things. So thank you very much, Prof. Chair, and we would be available to answer any further questions that you may pose. Thank you.
Thank you. Thank you very much for your presentation. I think the two presentations have given us more than enough to start a conversation focused on the media. I will invite the members of the committee who have questions for both presenters or either of them to take their turn, and then after that we'll open up the conversation to the audience.
Thank you very much, Mr. Chairman, and thank you, Prof. Amin and Mr. Tanko. I ask just a couple of questions for your consideration. See, the presentations you have made are essentially for the media industry. Of course, the last question about legislation, laws, and the media rights have some concerns for the general public. The point I'm trying to make is that you've spoken very well, eloquently about the ailments of the industry, the media industry. But it seems to me that you haven't addressed what would be the concern of the general public that you serve. And that's very, very important because, and I'm sure most of us here will acknowledge the fact that for the average Ghanaian, their concerns today about the media are the professional and ethical standards that bother them all the time. And you know what I mean. So much of our broadcasting space, so much of our social media space, so much even of large sections of our print space are worrisome. They don't really add much value to the democracy that we are talking about. It's unethical, unprofessional, and so on. How do we address that? We do know that ideally, the best way to address that is self-regulation. But I do know from experience also that GIBA, for instance, has been very loath to even contemplate the idea of self-regulation. When the Ghana Journalists Association tried with setting up an ethics committee, all the editors and others boycotted it, so it collapsed. Where we are now, to convince so many politicians, so many of the public to have sympathy with you. Take, for instance, this problem that arises where some traditional authorities arbitrarily close down radio stations because, according to them, somebody has insulted the traditional authority or somebody has committed some sacrilege on air and so on. Invariably, in all of these instances, the community support their traditional authorities because they consider that the media concerned have been unethical or unprofessional, or mudidiatem, and so on. So, yes, the Constitution must give you the rights, but the rights are not absolute. The absoluteness or non-absoluteness character of the media is what you deliver to the public. So what must we do to also improve media standards whilst also pursuing the rights of the media? That's, for me, very, very important. The limitations that Mr. Tanko talked about are largely derived from the ICC PR, the International Covenant, and so on and so forth. And many governments repeat these and so on, and of course use them for various purposes. But again, how do we cure that problem when professional standards are such a problem in the country today? It will be very difficult to convince the people who must endorse those proposals, looking at the situation that we find ourselves in. So there must be some give and take. Unless the media are prepared to regulate themselves properly, there are many politicians who are going to say, no, no, no. If we do this, look at the situation as it is. So I come back to that question of self-regulation or statutory regulation. How do we strengthen the National Media Commission to ensure and enforce ethical and professional standards? I think we must consider those. Mr. Chairman, my last point goes to Professor Amin and the Ghana Broadcasting Corporation. One, in your own view, what is your own perspective? You raised two issues concerning a clear definition of state-owned media or public service media. What is your preference and why? Second, when it comes to the financial sustainability of GEC, every government will tell you that we don't have money. That's always, and then you will be seen. But also, I think somewhere in the recesses of the minds of people in government, they look at you as part of the broad broadcasting landscape. If these media are doing well, why should you come to us? This is the mindset that has blocked the implementation of the TV license payment, even though it is sanctioned by law. So how do we respond to the authorities on these matters? Thank you very much, Mr.
Thank you very much. And picking up from where Prof. Kakari has left off, regarding the financing of GBC, in your presentation, you gave us examples of countries where the state is funding, public service media, etc., UK, etc., etc. But, currently we're seeing that even in the UK, even in the US, questions are increasingly being raised. And even in the US, they've gone as far as, trying to legislate, that VOA and others shouldn't be funded. In the UK, questions have come up about the TV licensing, etc. So in the light of that, what do you think, should be done? Because we can't just take the examples of those countries where even they are retreating from what they used to do. What is the sustainable way or mechanism to fund GBC or public radio media in the light of this? And also to tie to that, what percentage of your budget is coming from, internally generated funds, and what is coming from the state? And I'm asking this in the on the basis that our assumption that it could be possible to say this percentage of your services are kind of like, what do we call it? Not really operational, but in the public interest broadcasting. And so that percentage should be funded through the state. And then this other percentage is maybe more, a bit commercially oriented and etc. So that, again, we see how to deal with that. And a broader question around the digital and online media. Questions have been raised, people have raised issues, and whenever these things come up, then the response is regulation, tighter regulation, etc. So what do you think, we can, how do we protect digital and online media rights while, taking cognizance of all these issues that have been raised and, and the challenges? Thank you.
Thank you very much for your presentation. I have two questions, one for, I think it's on here. It's on. One for Professor Amin and one for Mr. Zachariah Tanko. Well, Prof. Amin, you mentioned BBC as a model of funding when it comes to the public service media. I want to know from you exactly what do you want us to direct our attention to in the funding of the BBC? That's one. And then with respect to our good friend Zachariah Tanko, in your presentation, I get a sense that you are not very comfortable with phrases such as necessary in a democratic society. You're not happy with reasonably required because you say they are nebulous, they are vague. And I want to find out from you, are you suggesting to us that we should take those words out? And if so, what do we replace them with? Considering that these words have been provided in the Constitution to strike a delicate balance between the freedom of speech, the right to broadcast, and also the protection of other rights. So how do we strike this balance? Because as you've rightly stated, no right is absolute, and therefore there is need for the striking of good balance. How do you achieve that if we are to take out these moderating phrases, we call them? I thank you.
I'm following up from what my three colleagues have said. I hope in your papers that you present to us, you add a definition of state-owned media and public service body for us to work on. So that I want it to come from you, from your own perspective, and then we'll build upon that. And what about the idea of making the media a constitutional body? Yes, a constitutional body, so that to be fully protected, so that the tenure of office of the directors and everybody to be protected. What about that? So if you haven't thought about it, think about it. And then my question to the second presenter, he was concerned about publication of false information not being a criminal offense. If it is not a criminal offense, then what, in your opinion, should it be? Because if it is be civil, then it means that a lot of journalists will end up before the court for libel and slander and the rest. So what is the proposal or the midway to protect press freedom and pressmen in general, the media in general?
Thank you for those two excellent presentations. My first question to Prof. You talk about the state-owned media, or at least GBC, having these dual public interest mandates that's peculiar to state-owned media, universality of access, and the diversity, of content, and how that pulls you somewhat away from being a purely commercial kind of enterprise. But of course, there is also a commercial angle to your work, and these two public interest mandates do not necessarily either prevent you from basically operating commercially. I think all state-owned enterprises face that kind of duality of mandates, be commercial, be profitable, but you do have public interest mandates added onto your task. And I think that's basically a dilemma of all state enterprises. In the current environment in which we operate, with IGF becoming, every state institution is doing internally generated funds, basically raising money commercially or in some other way. Explain exactly what disables the state-owned media from, making money in the current space in which we are. Of course, there's competition from private media. You are losing market share. Your monopoly is gone. But that is the environment in which we are, and some are competing in that same space and thriving. So what exactly, notwithstanding these two public interest mandates, or maybe that's what's not making you able to survive. Then the second one is, explain a little better for me how this inability to replace staff you're losing. Why is GBC unable to replenish staffing? I wasn't quite sure exactly what is causing that. And then this having to go to the minister for the budget. I understand, I think you really did, you explained very well how insulation from government control, on the other, has a flip side, which is that it also makes it difficult for the government to open its purse and give you money. No, but why isn't the NMC doing that instead of you? Why must you go to the minister to get money? Isn't it part of the NMC's job? If it's insulating you from from governmental control, I would have thought that part of its job in terms of insulation is to actually take it upon itself, as opposed to the organization or the GBC itself going to a minister to plead its case for money. Why isn't the NMC, what's the role of the NMC in your funding situation? And which brings me to the NMC itself and how it's exercising its mandate. And this also goes to, I think, the second presentation by Mr. Tanko Musa. The NMC issue about content regulation has come up. Clearly, there is, there's of course a Supreme Court case on this matter. Article 178, also 173, sorry, also does seem to appear to have language there that limits the ability of the NMC to push forward with some of the issues that Professor Kakari has laid bare on the table. And this is really, I think, the elephant in the room, is that there's not that many Ghanaians now are sympathetic to the issue of media freedom. We've had Afrobarometer data, it seems somewhat corrected, but at some point, there were actually more Ghanaians than fewer who were supporting further serious control of the media because of abuse of freedom, right? When we first found that data in our survey, we were a bit alarmed that all of a sudden Ghanaians are becoming almost hostile to media. So, but that is really at the crux of the issue, that there are a lot of people who think that the problem with the media today is not one of a lack of freedom, but an excess of it. And that the space has become a Wild West, unregulated, anything goes, people just say whatever they want, abusive language, some language bordering on obscenity, pornography, just all manner of things, right? So there's a lot of conversation around content regulation. And yet one has to, of course, strike this balance. What would you propose in terms of the role of the NMC? It has come up for discussion. Do we take another look at its functions, its powers? What must we do to enable the NMC to do a more effective job of regulating the media space, possibly sanitizing it, without tipping the balance against freedom? And I think that is the dilemma that a lot of us face. Issues have also come up about the NCA versus NMC issue. One is supposed to be a technical regulator or issuer of whatever it is that the NCA is supposed to do. I'm not too sure. I understand the work very well. But there seems to be a tension between these two state bodies in terms of the regulation of the media space. And because one gives what it is that you need to operate, I think over time it has more or less accreted more power over the media, because you do need their license to operate, or more or less their technical permission to operate. So it has unbalanced this relationship. One is in the Constitution, but the other appears to have more power. And how might we deal with that relationship that we're seeing now? And of course, neither of you mentioned it, or well, I think Musa mentioned it a bit, touched on the issue of ownership, which has also come up. There are concerns around especially politician ownership of media and the scale of it and the extent that it appears to have gone, and how that affects issues of polarization, issues of social cohesion, and some of these other issues. Maybe any one of you could actually reflect on that, and if there are possible ways in which we can help, because part of the goal of this exercise as we see it is to improve our democracy, to improve our governance, help with social cohesion. These are some of the principles, guiding principles that we have agreed as a committee to be informed by as we make our recommendations. Everything we do must help to improve the workings of the democracy, must help to improve governance, promote better accountability, help with social cohesion and the country's development. So these are some of the issues that I would want you to, both of you, to help us answer. And then the last would be social media, AI technology. You know, how is it affecting all of this? I mean, I thought one of the things that Professor Amin was going to tell us that the technological assumptions underlying the Constitution, when it had those provisions about state-owned media, no longer make any sense, and that you are even at risk of disappearing because of technology. Of course, you have indicated that there's a risk of that happening, but not coming from technology. You know, exactly how is technology playing in your space, and what is it that can be done, if anything at all, to deal with this issue? So our online members have a question, have sent some questions. So Dr. Esi Ansa has, funding. Great. So what percentage of GBC's budget comes from IGF versus what you expect from government? You know, so really the same, more or less the same issue that I was asking about IGF. Thank you.
So one quick question. In parts of the Constitution where a representative body is needed, you know, for, in some of the provisions, you know, the name like maybe GBA, Ghana Bar Association, etc. Should that be the case for GJA, that we see it as a representative body of journalists and that it can, you know, be mentioned in the Constitution where they are referring to representative bodies? Is there. But what I'm asking is that still the case? Because even for Ghana Bar Association, issues have come up, people have raised concerns that don't specify, but just say maybe a representative body of engineers or a representative body of journalists, etc. So I would like maybe your take on that. Thank you.
So you know, under Article 166, I mean, to go back to Mr. Alaji Tanko's point. So it's interesting that when we're looking at the composition of the GJA, of the NMC, almost all of the other institutional, you know, members are named specifically, right? Except when it comes to the training institutions of journalists and communicators. Right, so 15 members, one representative each nominated by, and their Ghana Bar Association is named, the NAT is named, Ghana Advertising, and of course the thinking is that these are not constitutional or state bodies, so you don't name them in the Constitution. You just find a way to describe them. Say, you know, the association representing lawyers or whatever, recognized in the country or something, the association representing advertisers or whatever, but that's what we have, right? They are named. And it's interesting that it doesn't, I mean, then it has two representatives nominated by GJA. It's also there. And I think the question is, should we begin to take out specific mentions of that kind and rather describe them generically so that it doesn't appear that we are constitutionalizing the GJA, the Bar Association. These are not constitutionally created. So why do we name them in the... It's a task, I guess, for us, the drafters, or, it's a tough task to redo these things this way because it's all over the place and it's been done already. Other constitutions, more modern constitutions coming up, don't do it that way. The Kenyan constitution doesn't name any private or non-state body in the constitution. It describes them, and you know exactly what they are talking about, but they are not named. It may be too late for us to correct some of these things, but I think that is what the dilemma that Alhaji Tanko is posing for more like the drafting. How do we clean up these kinds of specific mentions of non-state bodies in a constitution or private bodies in a constitution?
So let them answer members' questions. And then we will Yeah, thank you very much, Mr. Chairman. I want to start from the beginning. And there was a general question that Professor Kakari raised about the concerns of the general public vis-a-vis all the issues. And I think that sometimes when it comes to GBC, I want to tell you that the concerns of the general public affected are never heard. Before the coming into force of this constitution, and before the digital era, GBC covered Ghana more than it is doing today. If you drive on the margins of this country, from Chereponi to Bolko to Paga to Osei-Kojukwu, what will strike you is the fact that along all these border district capitals, the signals you will hear in your car radio are either Togolese or Ivorian or Burkina Faso. Today, as we speak, it was not so. It was not so because GBC was given the resources to operate 48 locations across the country to ensure that radio signals are strong enough. So anytime you see a conflict in these places, one thing that will strike you is that they have no media. The last one I remember was Chereponi, when they were fighting, and we were pleading on them to stop. They were not even hearing any Ghanaian radio station or TV telling them. Because if you go to Chereponi, the only radio you listen to is Togo FM. Now, the point I'm trying to make is that globally, despite the backlash, and may I correct this, VOA is not a public service broadcaster. VOA is a department of the Foreign Service, American Foreign Service. It's used as an instrument of soft power. Rather, it is the Corporation for Public Broadcasting in the US, which receives federal funds to fund about 1,000 public service broadcasting systems across the United States. So when we talk about the VOA, it is not counted. It is simply an instrument of soft power for American Foreign Service. And even until the internet era, VOA was forbidden from broadcasting to Americans. If you are American, you could only listen to VOA when you travel outside because it was forbidden. So the true public service broadcasting in the United States are those funded who receive funds from the Corporation for Public Broadcasting. And that is what Trump tried to, and he was reminded that they are determined by law. They are not like VOA. They are separate. And so funding public service broadcasting has never been more important than now. Now, I will say this. If America and Britain funded their public service broadcasting to develop their democracy to the level that they are, and they are now ready to dismantle it, it doesn't mean that where we are in Ghana today, we should be listening to them. We need to also fund, at least for the next 50 years, to make sure that media access is democratized. Civil culture is developed to the extent that we can now say that we have also arrived, and let us discontinue it. For now, we cannot learn from them. We must learn from their history, not their current practice. So they can go ahead and discontinue it, but we need to remember that we need at least 50 years of funding public service media to get there. So what I want to point out, and I've done this myself, as Director General of GBC, I've deliberately driven, it has been a very rigorous travel. I got sick through that. Traveled throughout the margins and came back. And I was alarmed at one consistent story. In fact, at Wa in the Upper East region, Upper West region, I found out that people were going to Burkina to pay for funeral announcements. In fact, that is why last year we had to replace our transmitter in Wa. Thankfully, today as we speak, our signals go beyond Upper West, and it hits into Burkina Faso too. Bolga had the same experience. We got a transmitter last year to do just that, to ensure that when it comes to signals, we should also go across the border so that no Ghanaian can say that I can't hear Ghana radio or Radio Ghana. We've passed that. And this is the point we're saying, that the concern they have, we are not even capable of hearing them. The only time we hear is when they take guns and knives to resolve their differences. That is when we will know that they are Ghanaians. So the point I'm making is that the concerns about the public is the fact that we are not even capable of learning them about them, but we have the story to tell because of what we do. Now, the question was asked, what are my preferences? We put together two options. Frankly, statecraft is a very funny system. If I made a politician today, I will do everything to have my way. So state-owned media is not the way to go, in my view. A truly public service broadcasting setup where state officials have no business talking to. Anytime you ask that the state has the capacity to give resources to an institution, it goes with a certain leverage. And that we can cure by simply going for a truly public service broadcast. Now, there are models. Now, the British people started a TV license at the time when TV was the most popular electronic gadget. Now they are stuck with a heritage. When the Finns learned from them, recently they said, no, the word TV license is dead. They have put in place what they call a public service media tax. 1% of every adult Finn's annual revenue, income is devoted to fund the YLE. YLE is the equivalent of BBC in Finland, or GBC in Finland. And YLE today is not allowed to do commercial broadcasting. They are one of the best, strongest public service systems in Europe. And their model is simply 100% funded by the state, by public funds, with Parliament having the authority to do that, allocation, which is simply defined as 1% of the income of every adult. And that is working. The BBC model is suffering because people sometimes say that, okay, why should I pay TV license? I don't even watch you. And I say, no. You are not paying TV license to watch GBC. Whilst you are in Accra enjoying more than 100 TV channels, your compatriots across the country in the fringes and in the hinterland are not good media market to attract the private media. GBC has the responsibility to get them on board so that you don't have to budget for a military intervention to go and fight. And you see, it's a very funny coincidence. I'll tell you this. Boko conflict, GBC had just finished setting up an FM studio to start broadcasting. Then the conflict took us away. If you go to Baku today, there should have been a publicly funded GBC outlet, ensuring that only proper public information is given out to control abuse of radio or any other form of listening. And I can tell you that in the last 3 years, we put up an FM station at Yendi, exclusively GBC FM station. About 2 years ago, there was a near outbreak of conflict. But thankfully, the MCE, and it was a conflict between the governments, they gathered the two sides into the studio, and they gave out the true story that what they were seeing on social media was lies. And that, now, a private media in Yendi might not be able to sustain itself because of advertising revenue, but publicly funding a radio station is very important to prevent any conflict situation. So that the question is, how do you justify funding GBC when the private media is doing its work? And I have a simple question. Name me one private media in Ghana that is broadcasting in more than 5 Ghanaian languages. We are doing 27. And we are telling you that it's not enough because we have more than 50 Ghanaian languages that are out there. How does it feel to grow up in a community as a Ghanaian and the only radio station and TV station you have is somebody's language? They are Ghanaian languages, but it is not your language. And you are growing up, your sense of belongingness. So the concept of universality of access and diversity of content is foregrounded to say that public service broadcasters can never run away from that responsibility. We have done 27. We still have a long way to go, but there must be an understanding that the right to listen to radio or television in your own language is not a privilege. And it should be something that public funds must be. I was telling somebody that the analogy is like this. You have your child in private school, but you do not contest that public funds be used to fund public schools. Precisely because your children, even though they are in private schools and you can pay for it, are going to live with those who are coming from the public schools to all share in the same common. So fundamentally, whereas public service broadcasters have civic identity building as their mandate, the private media systems are into consumer culture building. These are the two distinctions. So private media are into consumer identity building, whereas the public service broadcaster has a primary mandate to focus on letting people understand their sense of belonging. So that's why sometimes they say our content is boring. It's boring precisely because we are into the business of, not into business consumer culture growing, and we cannot run away from it. Now, so that is why there's always a justification globally to fund, and I'll give you an example, Mr. Chairman. The European Media Freedom Act, which has recently passed, has given August 2025 deadline for all European countries to ensure that their public service broadcasting units have editorial autonomy and stable funding. And it is to come into force in August 2025 this year. They have passed that act to make it mandatory across all European Union member states. There is no any decline. There is a serious interest, even in the era of multiplicity. And at the same time, way back in 2007, the same European Union agreed that in view of new media, public service broadcasting systems should open up their mandate to include digital platforms. That is why the language is public service media, no more public service broadcasting. So that the literature today is not talking about public service broadcasting, but as public service media to include online, digital platforms. The bottom line is not the reach, it's the focus of the content. Whereas public service broadcasters have a mandate to build on civic consciousness and identities, private media is more interested in consumer culture development for good reasons, and nobody can begrudge them for that. That is how they make their money, and that is how they have to survive, and that is how they fund themselves. So, like the so-called global backlash on public service broadcasting is something that is passing. I will draw your attention. Even Margaret Thatcher won election to shut down the BBC. Every politician of the other side, when they come, they are on the onslaught, but they soon realize that they can't do it. The only country in Europe that has ever made a mistake of shutting down their public service broadcasting was Greece. They shut down their public service broadcasting on the 11th of June 2013. And on the 11th of July 2013, they were forced to bring it back. The politicians were in a haste to probably, and I'll tell you the beauty of when you collapse a state broadcaster like GBC, and you are in government, you are going to feast on the assets of GBC, like what happened to Ghana Airways. So if I'm a politician, I'm in government, I'll pray for the collapse of GBC so that we'll take a decision on the assets of GBC. So there's always an attraction. The Greeks went through that. And just before they were able to liquidate the assets of the state broadcaster, the Senate called the government to order and they reversed their decisions. 1 month after dissolution of the public broadcaster, it was brought back to life. So I'm saying that apart from that Greek experiment, which went disastrous for them, no sensible democracy that we know has said they are going to downplay because there's now private media. They are going to focus on that and let the state media or the public service media go down. Rather, we have to discuss how do we fund it. And there are various models. The BBC model, the Finnish model, there's a Canadian model, which they are now regretting that it's not a good model because Canadians don't pay TV license, but they get all their funding from the state, from the public resource. And there are arguments about justifying it. So there's a question about what percentage of our IGF and the GOG funding. A few years back, it was something like 20% IGF, 80%, but in recent times, we have managed to come to 1/3 IGF, 2/3 GOG. And I can tell you this, if government was to pay for what the Constitution have asked us to do, if we were to cost it and add it to it, we would have gone more than 50% IGF and less than 50% for GOG. But we carry these obligations, and we are not funded. We are not refunded. When, as a CEO, I fear election petitions. The last election petition, GBC had to spend $5 a minute to a satellite provider to give us live coverage to the studios. In the years past, there was a line of sight between the court and GBC. But in recent times, we have had some high-rise buildings, which has made radio link impossible. So with that development, you must use satellite link. And the only satellite link we could get at that time was a service provider who gave us $5 a minute. So for every minute of the court sitting, we were paying $5 from our IGF. We wrote to government, we wrote to the Ministry of Finance. I even convinced the Chief Justice to write to the Ministry of Finance, all to naught. Nothing came out of it. We've had to fund it from IGF. So anytime the court was sitting, we're praying that they should end the sitting very soon. Now, it is not really pleasant. And that debt, it took us 2 years to pay it, just for that court process. So it is not a pleasant experience. Recently, the parliament will come and get free airtime. And recently, they asked, after they passed a law to tell us to pay taxes on our distance, we told them we are no more giving them their regional coverage. So when they go to the regions, I ordered my regional directors to deny service to parliament because they were not ready to pay. Yes. And they called me to parliament. I told them, I can't change my mind because you don't help me pay the electricity bill. So that is how we are. It's a battle to run GBC. You always have to fight with the politicians. But what is important is that once you know that the NMC is behind you, you stand up to them and tell them your peace of mind and stick to what you are doing because they do not have the power to send you home. It's the National Media Commission that appoints, and that is very important to ensure that GBC functions. So how do you regulate digital platforms? You know, the story of digital platforms in Ghana, it's a long story, and I think that first, let's go back to the Ministry of Communication and ask them to declare Ghana as having digitally migrated. We are yet to officially declare Ghana. And I think that that is something that we must do. The official deadline we had agreed as part of international convention, I think was 2015. We kept refusing or postponing. We need to declare that we have declared. Then two, we have to appreciate that regulating the digital platform is not a national affair. It's a regional and continental affair. But once you are able to do this, you should be able to enact laws that will be respected by other countries within your region. It will work. Digital platforms are run by giants who don't care about national laws, and they can easily say the woman. But if the whole of Africa or West Africa, ECOWAS region says that Facebook, these are our laws, respect them, they will respect them, because the market size is reasonable enough to attract their attention. But if only Ghana or Togo says that, they will ignore you. In fact, they did it to Canada and Australia, because they were single countries telling them, and they had their way. If they had their way with Canada, what else Ghana can do? Ghana cannot. So my advice is that we need to appreciate the fact that the digital story has to start with the government declaring Ghana as having digitally migrated and inform the ITU that we have arrived. And then locally put in place regulatory and laws that, and also promote a region-wide, ECOWAS region and African-wide regulatory systems. And it will work if we do that. But alone, we don't have a chance. So the funding of GBC as a public service media, I think that, like this conversation, I've touched a bit on it before, there are various models. We can study all these models and adopt one. My preference is the Finnish model, where they have dropped the word TV license because, I mean, it coincidentally happens that I was a student in Finland when they were about collecting TV licenses. And the rule was that when they knock at your door, don't open. Once you don't open, they cannot collect the license for you. You already paid the TV license. And yeah, but they have changed the law to say that, look, we don't have to go around chasing TV users. Every adult should contribute 1% of your annual revenue. The reason being that you don't have to watch TV or radio. It is to fund the public good, and that is where we have to come and ask ourselves. When you go public service broadcasting, you have to define what public good means. So that GBC, for example, will be taking off this advertising business, go off it, leave it to the private media. You are publicly funded to do broadcasting for public good and define the public good. What they do is that there are thresholds for monitoring. There's a systems of accountability, very strong, rigorous systems of accountability. Because I am the last person to just say that we just want to be funded. No, the GBC, I know, we need to be given a system of justifying our existence. That has to be built into the process so that we are properly, we can defend and justify why we are resourced. There must be an oversight, like the BBC model. The auditor, external auditor comes in to audit their processes, and they have to go to Parliament to get, I think, somebody can help me, is it 2 years or 10 years, to get a mandate to renew their existence? Because you have to first prove that you've used the money well to justify your existence for the next lease of life. That is what we, yes, 5 years. You must go, and they will check and make sure that you are really, and one of the things they do is that they also check audience survey to see whether they are satisfied with their service. So they are always trying to make themselves relevant, unlike if you put up GBC like that, we will sleep. Put in mechanisms to ensure that we are accountable. Now, to make GBC, there's a talk about making GBC a constitutional body to make a tenure, as to protect the tenure office. Yes. The last time a British politician tried to tamper with the position of the Director General of BBC was in 1952 or so. And he was so embarrassed that no politician in the UK has ever tampered with the BBC. We can learn from that. What have they put in place to ensure that it is protected so that there is no interference? That was the last time a politician tried, a prime minister tried to fire the BBC Director General. And he was so embarrassed that the opposition took it, and it's so embarrassing that no politician has ever tried. So the question is, how are they set up so that we can learn from that? Now, there was a question about, okay, so you have a mandate to do commercial broadcasting, you have a mandate to do public sector broadcasting, so why are you not making the money? I have the singular privilege of serving GBC as the longest serving DG since 1992. So that's my record. And I have a lesson, I have the lesson to share. GBC, my preference is split it into two, commercial wing and public service wing. If you work in the commercial wing, your salary structure is different.
But you don't need constitutional review to do that. I mean, isn't that a management, corporate restructuring division?
We require a review of the law. And we are also told that state, either in the Public Financial Management Act or, I have to confirm that, but what we are told is that we are not capable of doing that. We've tried it before, and we were told we can't, we should reverse it. For example, the law setting up GBC sets us up as a transmission entity and as a broadcasting entity. So as we speak, we have a unit which also carries the signals of private TV stations. Our system can carry 27 channels. We are using 7. So the rest of the 19, we've rented out to whether Joy is on it, TV3 is on it. They are all paying monthly to GBC. That is transmission. Now, it is because GBC was the first to experiment digital transmission, and it worked. And so we are making money out of it. We tried to set up a separate, that was before I came DG, a separate entity to run the transmission. Because if you go to South Africa, Centec is a transmission entity which is independent from SABC. But SABC created Centec as a private setup with different working conditions. We tried to copy that, but we were told it was illegal and it was reversed. However, they also said we should shut down our transmission system. That's when we told them the law says we should be a transmission entity and a broadcast entity. And I remember very well that under the previous government, they came very hard and said a cabinet decision was taken that only NCA will be a transmission entity. And I told them that as far as I checked, they haven't reviewed the law, which was put in place in 1968. And that law says that GBC is a broadcasting entity and a transmission. And until they review that law, we will not shut down. They backed off and allowed us to continue doing that. So what I'm trying to, from that experience, we are going to face a lot of resistance from the executive arm of government, which will deny us the opportunity. But half of our channels can be set up as private TV stations and radio stations. For example, we are supposed to be, public service mandate requires that we have at least in every region an FM station. In Greater Accra, we have 2. Obonu, which is doing very well, and Radio Unique. My view is that Unique should be a private radio station, separate, because we have already honored our mandate to Greater Accra as a region. So we don't need a second public service broadcasting entity. But here we are told we need some legislation to set up a private entity. But GBC, we should do that split, because I'll give you an example. In the last 4 years, I have lost very good staff. And because the private sector gave them better conditions. If they were in the private unit of GBC, we will make it difficult for the private sector to come and poach them. But all the TV stations of significance in Ghana have poached staff from GBC to do what they are doing, because they are able to offer different working conditions, whilst I am tied to public service conditions, which will not help us to do business.
So you are helping to build, a pluralistic media, training people for, private media.
Then in that case, we should be compensated.
So I have been alerted by my staff that we have to take a quick coffee break or tea break. There's lunch is around 2:30, so we can take a break and then a short break, come back, have more conversation on this, and then open it up
Maybe
before
Chair,
lunch.
If I could finish my 3 points and then we'll go.
We'll be back. I want you to come back, because if I allow you to finish, you'll probably run away. So,
No,
So you stay with us. We'll just take a very short break, maybe 10 minutes, because lunch is fairly close. And we'll come back and continue, and then we'll take a break for lunch, come back. We are billed to end today around 5. a lot on our plate, and we are back from our very first break. You know, as I listen to Professor Amin, fill those questions and talk about his dealings and encounters with government and finance and all of that, I thought to myself, you probably have a better parent or guardian in the Minister of National Security. It's like, if you were successful in having audience with them, they will probably understand your situation better than the finance people, because the finance people are always managing the purse, but from just the description of the work that you're doing and its public importance, I think
actually doesn't sit well with the constitutional provision that talks about installation. So this has been the story. But it was easier to fight when it was at the ministerial level, because I remember very well that there was a request in the previous government from the Minister of Information, and I told him it will never happen, and he has to go to the NMC. But now you're asking me, I should tell the Chief of Staff it will never happen? I don't know. I will expect that this issue of NMC and GBC vis-a-vis the government, we should cure it permanently so that you don't have any preferred definitions. If you define it as a state enterprise, then the Public Financial Management Act, the SIGA law are all brought to bear on it, and you are simply treated like Ghana Water Company. You are treated like any other state enterprise. But if we make sure there's a clarity on NMC's oversight over GBC in a way that there's a clear, the insulation clause is actually brought into practice, it will help.
So in the current model of state organizations that we have, which one would you say, for example, that you want? Would you say the universities, so the public universities, you want a relationship that insulates you more like public universities currently?
Oh, I think I am from the university system, and I can tell you that in the last decade, we have seen the state redefinition of that distance. We have seen that crashed, because these days, the SIGA Director General issues letters to universities that we think it violates.
Oh, I see.
Yes,
okay,
yes,
so
yes.
even the universities are
we have
not
begun
free.
to see some kind of micromanagement of universities that really surprises us. Because basically, it used to be the university council, the university statutes, and that was it. But today, GTEC issues memos, letters to universities that tells us that that distance has been collapsed, and there's now...
So there's no public institution that you could say, well, we want to be like this in terms of our relationship with the government. If we could get this kind of a relationship, it would be
No, I think that we can look at, for example, what is the relationship between the EC and the government, for example, electoral commission.
Oh, that kind of relationship.
Yes,
okay.
For example,
So
what
the
is it like?
constitutional bodies.
Yes. We can look at that, something like that. But basically, this state-owned media is defined as a state enterprise. And like all state enterprises, the executive think they have all kinds of leverage on you. And that, we think, needs some clear definition. Now, there was a point raised that they wanted to hear about social media, AI, and then that ties into the last question, which has to do with the relevance of public service media. And we are saying this, look, in a democracy, you have two ways of looking at the media, all. They are institutions of democracy. At the same time, they are business units with ownerships. So no matter how you have media pluralism, fundamentally, the tendency for media concentration in the hands of a few is a logical step that happens to all democracies. Public service media, and I gave you an example earlier why the European media, the act is set to come into force on 25th of August, which is simply saying that all European democracies, European countries, must ensure that two things happen to their public service media. Even in the era of AI and new media, they should have editorial autonomy and well-funded. Now, I gave an example earlier about Finland. Finland has, in fact, I would say that when it comes to IT, social media, and they have been advanced than the rest of the world. Today, the most trusted and best social media platforms are owned by Wiley. That is the public service broadcaster. Private media are very fantastic. They ensure media pluralism. But fundamentally, they are privately owned. And in times of critical national moments, the private interest will override the national interest. So any democracy that completely ties its to private media, the risk is that And that happened in Berlusconi's Spain, where at some point he owned 75% of the media in the country. Say it again. Italy, sorry, thank you. He owned 75% of the media, and he did what he wanted. But the importance of public service media is one, ideally, to take it away from advertising market, to do exclusively public service broadcasting. And that is what the Finns have done, and the result is fantastic. Despite the IT savvy of Finns, I mean, today, the best social media platform and the most trusted social media platforms in Finland is Wiley. And there was a survey conducted about some 5 years ago, and they asked citizens, whom do you trust? Number one was police. Number two was Wiley. Police. But number two was Wiley. That is the Finnish public service broadcaster. Because it is insulated from advertising business, and because it is well funded, they do professional public service broadcasting. And they trust their institution. That is what we are saying that. And secondly, let me bring you to the other side of this euphoria around IT, artificial intelligence. Please, put on your data and travel across the country and see whether when you move beyond Accra on the road, you'll be getting data. Find out the digital access numbers for Ghana and see who is not on it. And who will it take the next 5, 10 years to be on? And what are the determining factors? Cost of data, internet connectivity, and the telco networks. And I'm saying this so-called AI and new media is a beautiful conversation by urban dwellers like us. But for GBC, we can assure you that we have large swaths of the country where, when it comes to accessing information, even if you have a smartphone, you are not going to get it. You will have to rely on the public service broadcaster too. And I also tell you this. If you were to give me 1 million cedis, GBC, I tell you that 80% of the money will go into radio stations to keep them on, not GTV and not GBC News. That is how we operate. Most of our resources are into keeping our radio stations alive. And they are alive not to do advertising to raise money. They are alive because they make sure that at least what is happening in the capital, in parliament, in the court, at the executive arm of government, we make sure they hear it in their language, and that is critical. How to get them, and that is public service. That's why we keep saying that it's not about the advertising, it's about universality of access and diversity of content. And that is even in a case where everybody has access to social media, you will still need a social media platform that is trustworthy, and that cannot be subjected to the private interest of the owner of the platform. And that is what GBC does, is to cure the tendency for the private-owned media to seek their private interest.
Thank you. Thank you very much, Professor Amin, for fielding those questions. We will open the conversation to all the participants here. Sure. I mean, so yes, there are questions for you from the members, so you can take those questions, and then after that, we open up the conversation. We have 1 hour before lunch, and then after lunch, we are back. But let's spend the next hour to hear from all of you here, but we'll have Mr. Tanko Musa will take his turn answering those questions, and then we'll give it to the audience. Thank you.
Thank you very much, Professor Chair. There was a question from my lady where you asked whether are we trying to suggest that there should not be any form of intervention in the way the media exercises is right. Certainly, that's not the case at all, my lady. What we are suggesting is that, in as much as we recognize that the media, they have responsibility, if you look at the way those provisions have been actually explored, they have been explored in a way that has been so disproportionate. And if you take a cue from the Principle 13 of the Declaration of the Principles on Freedom of Expression in Africa, they do give some sort of guideline or framework in terms of if you're going to use the limitation provisions to deal with the media. They said that freedom of expression should not be restricted on public order or national security grounds unless there is a real risk of harm to a legitimate interest, and there is a close link between the risk of harm and then the expression. But what we see by and large is the fact that people just abuse the broad provisions. For instance, if you look at Section 208, when it talks about misleading, when it talks about tendency, all these things are so broad, and so it leaves room for sort of parochial interpretation that we see. And that same principle.
So what is your recommendation on that? So is the argument that the limitation clause in the Constitution when it comes to restricting rights, that the clause that limits rights is too broadly written, is too narrowly written, we must tighten the definitions? I mean, if we were to rewrite it, and I think that's often the kind of debate we have.
Yeah.
You have a right, and then it is restricted.
Yeah.
But the restriction itself is also restricted. In many democracies, the way they understand the restriction is that rights are not absolute, but restrictions are not absolute either. So sometimes the way you couch the restrictions is more important actually than the way you couch the rights, because everybody is looking at the restriction. Should we do something about the restrictions? Is that the focus of your argument, that we should take a look at the language of the restrictions and tighten it?
That's our suggestion. Our suggestion is that if you look at the provisions, where those provisions are made, we are suggesting that there should be a preamble where that preamble would provide some framework. So for instance, some interpretation. And then we are saying that whenever issues about the limitations are coming out, there should be some sort of presumption of openness. There should be issues about proportionality, and there should be some guiding principles, and this can only be done if those provisions are actually clearly defined. But the way they are couched now, it leaves room for abuse, and that is what we are concerned about. Yeah. There was also an issue, and I see my senior here, the NMC issue, and then we have actually suggested that this whole issue, and we've been talking about this for a long time, about the NMC's powers. Prof. Chair, you talked about the Supreme Court decision where when the NMC wanted to actually intervene as a result of the public concerns, and then if you like, the backlash that they encountered. And I don't know, but maybe George might talk to it later, where I didn't think the NMC didn't come back to do much about it. But what we are saying is that the powers of the NMC should be looked at, and it should be looked at in a way that gives them much more power. Because as things stand now, when you look at the NMC, when the NMC even invites people before them, people can choose to come or not to come. But we are saying that if we're going to give the NMC some powers to be able to deal with this, we should look at the provision where the NCA is providing, if you like, the license, and then NMC is supposed to be, quote and unquote, the regulator. We're saying that provide the NMC, maybe give the NMC some sort of quasi-judicial power where, I mean, if you are invited before the NMC and you fail or willfully refuse to come before the NMC, then you are taking the risk where maybe it could be a referral to the High Court in terms of contempt of court, so that the NMC would have that power to be able to regulate the space. But as things stand now...
You mean to sanction also?
The sanctions.
Okay.
But then the issue you raise about what the Supreme Court also said is the sanctions. What language? The language that was introduced in that provision was what actually the Supreme Court was concerned about, because they were worried that they've seen some language that by and large introduces censorship, introduces criminality and all those things. And my lady was asking the question whether, why can't we have civil remedies to deal with these situations? Oh, no, you are saying that, are we suggesting that we should take out the issues about criminal aspects? We're saying that, I mean, we had a conversation among ourselves where we're saying that, why not? Why can't we make provisions for issues to do with the media to be handled in a civil way? But even if it has to be done using the criminal provisions, the way things are now, it is not something that actually deals with the situation as we stand. If you look at Section 208 and the Electronic Communications Act, I mean, other jurisdictions, their high court, their superior courts have considered them to be inconsistent with the international conventions of media freedom and independence. But we continue to maintain them in our books. And whenever you raise those issues, the issues that come up would be that, well, freedom is not absolute. It is what? Qualified. And those qualifications are what is needed. You talked about reasonableness. These are vague concepts. If we talk about reasonableness, who is the reasonable person that we are looking at here? Are we talking about the naive person? Are we talking about somebody who is unusually suspicious? And by and large, what we see in our context is that you see that the actors, the political actors, always go to the side of either they will pretend to be naive, it satisfies their interest, or they will be unusually suspicious. And we are saying that let's deal with this lacuna by coming up with a framework where we would have a preamble that interprets the circumstances that could lead to an interference. And even when we have to maintain some of these provisions, there should be some sort of periodic review to see how things are being implemented and all those things. And yes, you are right, because the public is always very critical of the media because there is also the lack of media literacy in our society. And yet, they are also tilted towards the sensationalism. They like the sensationalism, but they don't seem to appreciate the fact that that sensationalism also leads to all sorts of things that they are worried about. So we have, in the extensive submission, we made provisions where maybe we need to consider issues about media literacy. At what stage in our educational curricula are we going to introduce it? Is it about time we introduce that in our educational system where media literacy would be part of our educational architecture? These are all issues that we have talked about. There was an issue about the prophecy. Which one was that? The media responsibility, an issue, and we have issues. The issue about economic independence of the media is also an issue, which by and large, the issue of media ownership. We have actually seen a situation where it is very opaque, it is shrouded in secrecy, and because of that, all sorts of people, especially political actors or politically exposed people, are actually getting the license to operate media houses. And as a result of that, because of the abysmal nature of our economic, independence of the media, this situation is abused and it leads to all sorts of things. We are also thinking about whether or not the ethics. Of course, GJA is a voluntary organization, so you may not ask everybody to be part of GJA, but the ethics, there is a standard code of ethics. And we are thinking that, well, if we are talking about professionalism and to make sure that the public is actually aligning with us in the way we do things, our code of ethics, we should find a way of linking, if you like, the regulator. When the regulator is issuing you with the license, it should be a way where when you get that license, it should be factored in your media management, where the code of ethics would be taken into account in terms of whether or not your license can be reviewed and all that. But the issue of the NMC came out quite a lot, and we think that the way it is now, its composition, the powers it has to be looked at if we really want to make some headway. I don't know whether at this stage, I may want to just open it up for my other colleagues. There was another question that I
chairman's
made.
job. You want to have the mic and then you circulate it within your clip. But I think we can open it up. Of course, other members of GGA.
Yeah, Mr. Chairman. No, I'm saying that at this stage, we want to come back to you and then maybe open it up for my other colleagues too.
Okay.
Also, yeah.
That's exactly what we want to do.
Yeah.
Okay, so thank you very much for again adding to the conversation. So the floor is open. 2 presentations, but like I said, you don't have to limit yourself to those 2 presentations. You have your own viewpoint you want to share with us. You are most welcome to do that as well.
Yeah.
So,
Mr. Chairman, just to add a bit, it's just an addition to what the Media Coalition had been talked about, has already presented. Actually, there's a conversation on the table about NMC NCA measure. I think that in the past elections, 2 elections that have been held, reports that have been produced, of which some of the observers, EU report specifically, has made some recommendations and has come to the table of the GJ a number of times, asking questions what we think as an institution about merging NCA and the work of the NMC, given the fact that they have been working, which has created some omission in terms of ensuring that there's that oversight and a responsibility towards the issues that are being raised about providing spectrum and not ensuring that these spectrums are providing what they need to, and who are actually owning them, and do they really need to own them, and the issue generally about media regulations that are coming up. I think that we need to consider the issue as we go along. And from our side, we've also talked about the fact that we actually need to have a dialogue on that particular issue, whether or not the NMC or the NCA should work in isolation or should be merged. We understand that one is a constitutional.
what is your position? So
my position, I would wish there should be.
GJA's position on.
I will not say that GJ because we never concluded on it. It's something that, and I believe that everything that we are talking about today is not ultimately a conclusion. These are all suggestions that we are tabling at this time.
We are going to make recommendations, very concrete ones. So we need help making those recommendations, right? So if you think that the better model is to have a unitary body, that's NCA work and NMC work all one. If you think that's a better model, I doubt that that is a better model, but if you think that that's a better model, then you make the case for it and you tell us why.
The question then will be, what role is NCA playing and what role is NMC playing? What roles are they playing? And how can they work differently or together if we need to ensure that at the end of the day, we are expecting the results that we're expecting? In terms of media regulation, which is a problem now, we all agree, given the way the media has metamorphosed over time. So if it's an issue that we need to look at, I would think that we need to look at more critically. But I will not conclude. It's still a suggestion.
We will conclude.
Yeah.
We need conclusion.
And also, just a little point, and then I can give it. I think the issue of one issue that I think is a issue within the media ecosystem and a threat to our democracy is the issue of misinformation, disinformation, and all of that. So as we deliberate, we need to look at how can we cure that issue? How can we cure the issue of misinformation and disinformation? Maybe not ultimately, but manage it. Manage it. We know before now that misinformation, disinformation was not a problem when we had just the state-owned media. So there was an outlet where if you wanted to manage information or get I would say, a certain kind of information that was tilted to the greater good. That's where you went to. But with the other media coming out, which we cannot eliminate, I mean, we need them as well. It's a free media, 1992 Constitution allows that. But I'm thinking that we need to look at how we can cure the issue of misinformation and disinformation as we are trying to amend some aspects of the Constitution. That's just my take on this. It's something that we have to think. I don't have the ultimate answer, but I think that it's something that we need to look at very critically, because we know it's been a threat even to our elections and all of that. Thank you very much.
Thank you. Yes, Brahma and then Kojo.
Thank you very much, Mr. Chairman. I want to start by saying that if there is one area where there has been a lot of shifts since the 1992 Constitution came into being, it would be in the media sector in terms of transformation, growth, as a result of which I think we've gotten ourselves into a kind of a fix where we certainly want to affirm the freedoms that must exist, but we've also come to a point where we need to also look at how those freedoms are being exercised. And I want to reference a position by Justice Afre in 1993 when there was a discussion about private radio broadcast in Ghana and what must be done. And looking at it from the legal point of view, he made a point about the framing of the Constitution and how, if care is not taken, we'll get to a point where media will become tools and avenues for committing fraud. And in fact, I think we are there. Because we are in a situation where we have media houses that are, doing money doubling broadcasts. We have a situation where people are using media for spiritual things, for perpetrating, issues of herbal drugs that will cure every disease and so on and so forth. And we are basically helpless. We have media houses that are essentially saying anything. Can say our military commanders are useless. Otherwise, elsewhere, what is happening in this country, there should have been a coup d'etat, and nothing happens. So we are at that point where Justice Afre predicted that the way things are, if we are not careful, we'll get to a point where the media will become platforms and tools for perpetration of fraud. And as I said, we are there. And his point was that perhaps we have a unique situation where we say the media do not require licenses or registration to establish. And I think it is the case as at now. And I think that is what inspired Reku Brobe, for example, to set up Radio Eye. And that, I don't know whether it has been concluded, whether I can set up a broadcast station now. If I don't need spectrum from NCA, then I can go ahead because I don't need license or I don't need to register. So I think we are at a point where we need to really look at the freedom provisions and generally the provisions within the media. First off, I want to perhaps comment on Professor Amin's points about public service media or GBC as it is.
May I take you to 1623, just the point you made about this license, right? So 1623 says, there shall be no impediment to the establishment of private press or media. Is this provision obsolete? Should we rewrite it?
I think so, because one of the points Justice Afre makes is, for example, that ideally there should be a provision for, if you want to set up a radio station, for example, a requirement on what is your financial capability? What is the board that you're going to, use for running the radio station? Are these people persons that, we would say, okay, if these people are behind the radio station, we can guarantee that they would comply with at least the basic standards, the basic ethics, and so on and so forth. But today, it isn't like that, and that is what perhaps the opportunity is there for every MP to own a media house, every religious leader to own a media house and so on. So, Prof, my point was...
But I think it's, I mean, can we stay on that point?
Okay.
It's a significant one, right?
Okay.
So, I mean, your point is, yes, to enter this market, to enter this, there should be some pre-entry regulation.
Yes.
Say you submit your documents, registration documents, your board, your corporate documents to a body, say the NMC.
Yes.
The NMC vets it, says, yeah, this is you know, an appropriate body to operate, and then the NMC recommends to say the NCA,
yes,
right? The one that gives you the spectrum, you know, so that we are trying to now figure out a relationship between these two bodies. But so maybe you could develop that idea further. I think it's helpful because if you are saying that there has been such significant transformation in this one sector since 1992, then the Constitution has to evolve to basically, you know, in the direction in which the industry is going. And I think this idea that, you know, you must have some pre-registration vetting of your, you know, whatever it is, and that if it is done by an independent regulator, then the risk that the government will use it to keep out certain other voices would be minimized. And then that regulator then recommends that, yes, you can grant a license, a spectrum or something.
Yes,
the question of licensing, as stated in 3 here, has a historical justification. Prior to the Fourth Republic, and since the 1960s, or even maybe the colonial times, if you wanted to establish a private media, you needed a license, authorization from the Minister of Information. And this had been used over the years to deny so many people the right to set up newspapers and so on. This is what the framers of the Constitution wanted to avoid. Nowadays, if you want to get a frequency to do broadcasting, there are certain things you must satisfy. The problem is not that there are no such prior, requirements. The problem is that because the NCA is directly under the executive, the political parties have bastardized its role, and any regime that comes in dishes out frequencies, and so because of that, there's no regulation there anymore at the national, and its operations are totally, lack transparency. This is where a major part of the problem is.
You would retain 1623 or in the present form in the light of the history, or would you go along with the line of thinking of Bremer, but then add more protections in there to prevent the first mischief that we try to cure, which is we don't want government or ministers issuing licenses, but we don't also want to go to the other end of the spectrum where it's a free market, it's free for all, there's no, you know, so somewhere in the middle is where we might settle, if that's with more transparency, more pre-clearance, but by an independent regulator and that kind of stuff.
I was a member of the first National Media Commission. Our chairman was Professor Kofi Kumado. We had such stalwarts like Alajete and so on. Now, when the NCA was being established, there was a proposition that the NCA is established with all its, but the process of giving authorization for broadcasting should be the work of the NMC. You apply to the NMC, and then the NMC processes and gives you authorization or otherwise. Now, the president at the time and the Attorney General, Minister of Justice at the time, told us that according to the chairman, it will be over his dead body for this to be done by the, what do you call it, by the NMC. And so everything was given to the NCA to do. Later on, over some time, they even allowed now a member of the, I think the executive secretary or a member of the NMC to be a member of the NCA board. But the argument has always been that the National Media Commission should give authorization, and then the NCA does the technical work of plotting the frequencies and supervising the other technical things and so on, but it has never been done. As to the requirements for whether you qualify to do this or that, it can be done, but it ought to be done in a way that does not also go overboard by introducing certain things that may disqualify certain people from authorization. For instance, if you were to add something like, you know, because we are worried about content standards, if you were to add something like, therefore, for every radio station to be authorized to start broadcasting, it must have the editorial staff who have a university degree. People will fight that. I would fight that because I do know that some of the problems we want to cure today are committed by people with university degrees. So that's neither here nor there. The point is, how do you regulate the content? And this is where the problem actually lies. And this is where the question of the NMC's powers are needed. And the NMC's powers should not also be such that they deny people the freedom to do the work. You can have a set of rules that a more professional, how do you call it, regulator, it's been done in South Africa, elsewhere. But also, you cannot say that, therefore, the NMC, you see, actually, part of the problem now is that the NMC also has the mandate to get legislation to regulate the media. It has made some attempts, but the courts have also frustrated the National Media Commission. George is here to say. So what we are talking about, it seems to some of us that we need a whole reconfiguration of that whole realm of media regulation and so on. You know, so perhaps.
So if I may proceed to make concrete proposals around that, my recommendation would be to say that to be eligible to set up a broadcast station, the preliminary point to cross would be to get the licensing, the broadcasting license from the NMC. And the NMC would have done the necessary vetting. Do you have the fundamentals to be able to have a professional media organization and all of that? And the NCA's job essentially is to look at the recommendation from the NMC and says, Prof. Kwesi Prempeh is eligible for this. As we speak now, if you want to know the true owners behind perhaps 70% of our radio stations, you wouldn't know. But if that requirement is there, the NMC would know that this radio station is being set up by Honorable ABC, and then these are the board of directors or the people who are subscribing to it. So we would avoid the situation where people are just going behind some people and setting up radio stations for political party propaganda and all the kinds of things that we are seeing. So if we have a provision that says an application shall be made to the National Media Commission, and based on eligible blah, 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 the Media Commission shall provide or issue a broadcasting license on the basis of which a frequency authorization will be granted by the NMC, I think, sorry, the NCA, I think we'll be curing something. I wouldn't say a merger between NMC and NCA. That's impossible because there are certain technical things that the NCA handles. I mean, data, the spectrum, the frequencies, the aeronautics, and so on and so forth. But here we are talking about broadcast media and what the NCA should be doing. I think the biggest problem we have in the media ecosystem now is the fact that there's a regulator in text and no regulator in practice. That's what it is. And I would want you to read the LI that Prof references, LI 2224, which was, I think in 2014, that the NMC tried to introduce to help cure some of the things that we are talking about, because then there was a requirement for you to submit some sort of programming to the NMC for vetting, so that if you breach certain requirements, you could be held accountable. But I personally also think, as a non-lawyer, that there were certain provisions in LI 2224 that I had a problem with, because we even issued a statement challenging some of the things before Giba went to the Supreme Court. But you need to also read the Supreme Court ruling, where it did not just say we are trashing it because it's completely irrelevant or it's not needed, but the Supreme Court in its ruling even said that the NMC knows what to do. If it wants this thing to work, it's not about completely abandoning it as has happened now, but that there are steps that can be taken so that particular provisions in LI 2224 that were problematic can be dealt with. And I think that the NMC possibly should revisit LI 2224, and I would also recommend that members of the commission should also look at that. The other thing that I want to bring forward is, in all this, we want to see a stronger media ecosystem. A media ecosystem that is able to hold duty bearers accountable as provided for by the Constitution, where it says all these freedoms are granted not just for the sake of freedoms, but so that the media are able to hold the government of the day accountable to the people of our country. So we need a very critical media, strong media, and all of that. But what is emerging is a phenomenon of a lot of arbitrarily caught cases, where people will just run to court on the basis of a story that has been done to expose A, B, or C, because they have the resources, either to stifle you, to prevent you from going on, or to maybe show you where power lies. We run the Fourth Estate, and we are dealing with a number of these cases, where quite clearly, in one instance, the president commissions an audit, auditors say there were contractual breaches, no value for money, then you are taken to court for defamation because you are said to have destroyed somebody's business in one way or the other. So we are seeing a lot of slap suits, as they call it. And I'm wondering whether in some way we can make a provision that journalists will have the liberty to challenge certain cases on the basis of they being slaps, so that there could even be early determination of the cases, just as maybe people do no case, there's a case to answer, and so on and so forth. So that if it is determined to be a slap suit, it is ended as early as practicable to allow journalists who want to do critical work to continue their work. There's one thing that I don't know, maybe George is here. Not too long ago, there was a company that was established, a state-owned company, for signal distribution. And I think it was a very, very dangerous thing that was being done, in line with this, our digital migration processes. The executive arm essentially established a company. George, I've forgotten the name. Is it Signal Distribution Company Limited or whatever it is called? And this company was going to be responsible for the distribution of television signals, all television signals, including GBC signals, said that if you broadcast some content that the company says we can't distribute, it means you've just broadcast, but it won't go anywhere. What that was going to happen is, if the government thinks this TV station, what they are churning out, we don't like it, basically your content is not distributed, and it stays there. And I think it's an existing company. We need to look at that. Our argument was that in Kenya, in Tanzania, and elsewhere, That function has been given to the state broadcaster as part of the mechanisms to even raise funding, because they don't distribute your content for free. And the state is doing that, and therefore the NMC has oversight over it, so that you cannot arbitrarily as government decide which station's content to distribute and which one not to distribute. So it's something that I think we should avert our minds to. George may even bring it up better, but if we allow it to stay, I think that it's a way to bypass the ombudsman role of NMC. And finally, I just want to touch on Prof. Maybe I have a bit of justification. I think GBC is still important, but not in the way we have had it all the way till now. Because, for example, talking about local language broadcast, before, let's say in the 90s, if I were in Boku and I needed to listen to a Kusal or Kusal as a local language being spoken on radio, the only way to get that was Ura radio in Bolga. If I were to do that, to listen to Dagare in Upper West, it would have been Radio Upper West. In Volta region, to listen to Ever, it would have been maybe the GBC station there. But today, I can have Kusal being spoken on Quality FM in Garu, Zebs FM in Zebila, Max FM in Binduri. You come to Bolga, A1 Radio is doing Guruni. You go to Upper West, Radio Radford FM is doing Sisale, Freed FM is doing Dagare. And if you go to these communities, the stations they will tell you they listen to as their source of information. It's not the GBC station. It is these local FM stations. So do we need GBC in the way it is, with FM stations all over the country and the cost to manage that and all of that? Or we need to relook at, we need GBC, but in a different...
access requirements.
Yes, yes. So I think those will be my my points for now.
Chair, thank you. In all the discussions around licensing and regulating stations in terms of content, there's one little bit that really bothers me that I don't think we've addressed, or maybe before I came in. The stations that operate in the digital space that don't require licenses, probably don't even have to be within the geographical borders of Ghana, do not get any license from whether NCA or NMC, and yet they're operating, and depending on how sensational their content is, they are gathering very large audiences. How do we manage those ones? Because in all this discussion, I think we're missing out on that lot, the borderless ones that don't have to be physically here and be subject to all the things we are debating. Thank you.
Thank you.
I think you're next, and then we'll move to the left.
Thank you. In fact, Madam Charlotte, you've kind of taken the wind out of my sails of the first point I was going to make. It was exactly about that digital space and how we need to update our laws to cover that. In fact, I think the boss of GBC made an important point about how the focus has never been on the digital, because in the estimation of the GBC that is trying to do public service broadcasting, the needs of those in the rural areas are not yet extended to the area of digital content. They don't have access to data, they don't have electricity, so really they are still relying on analog content, radio content, and so forth. I would like to encourage us, since we are trying to improve our constitution and we want to make laws that will stand the test of time, I would like to encourage us to write the laws regardless of our current problems and anticipate a Ghana in which everybody has access to data, and make sure that our laws will cover that time as well. Anticipate a time when our mothers and grandmothers in the village will be consuming digital content, and make sure that our laws regulate that. I think you were raising the issue of all of these other channels springing up that have been created by state institutions like the police. And the question is, should they all fall under the control of GBC, of NMC? Thank you. Well, I would extend it further and say, well, what about YouTube channels created by state institutions? The most successful, financially successful YouTube channel in the world made $82 million in 2023. That's serious revenue. And it's just because this individual called Mr. Beast is creating content that people find interesting. We're here in this conference room discussing matters of national import. There are millions of Ghanaians who would find this content interesting. We are streaming it live. Would we say that this commission is a state institution and therefore its live stream should fall under the regulation of the NMC? Should we be considering a future where such a live stream would be attracting millions of viewers, and therefore as a state we should be interested in what goes out there and how we regulate that content? So I'm thinking that we should be thinking of making our laws future-proof. We have current problems, but we should make our laws in a way that will protect us even after we solve our current problems. I have a question for GBC. This is just for my own curiosity. Since GBC is mandated to collect TV license fees, and we know that the compliance to that law is very poor, is there an option for the GBC to bring in private contractors to help with the collection, like GRA does? Is it an option, or will it require some change in the law? Because I don't see why we can't explore the option. Bring in a private contractor, pay them a percentage, let them go out there and collect the fees, because we are all legally obligated to pay them. But we don't. So this is money we owe the state. So get some debt collectors on the job. Anyway, that was just by the way. I would like to make a recommendation around the issue of equal access, as the Constitution prescribes, equal access to airtime by all political parties. I know that in your presentation you were suggesting that the government should support GBC to fulfill that requirement. Should we not simply recommend the scrapping of that requirement, since we are seeking to review the Constitution? Should we not just get rid of it? Because I don't see the benefit of that. I don't get the benefit. One day we may have 40 political parties all contesting in an election, and we have to give them all equal time on GBC. I don't see the practicality of it. Can we consider scrapping it entirely? I think just before I mentioned the 2 points made by my colleague before he had to leave, this issue around press freedom and the limitations to these freedoms. So I wonder, why is it that we think the only way to curtail a freedom is by making people criminals? Why must every sanction be a criminal sanction? If a typist makes a mistake when typing a letter, all they have to do is scrunch up the paper and find new one and do it again. Nobody sends them to jail for it. If a teacher misinforms generations of children, nobody puts them in jail for it. If a doctor prescribes the wrong medicine, there are sanctions. They might even lose their license, but nobody sends them to jail for it. If a lawyer misadvises his client, there are sanctions. He may lose his license, but nobody sends them to jail for it. For some reason, we believe that when a journalist gets it wrong, they must go to jail. So we have a law that was written long before the Constitution, back in the 60s, that says when you, if you get it wrong, and somebody somewhere believes that what you did is likely to cause fear or panic. In fact, the way the law is written, it says, if it's false and likely to cause public alarm or disturb public peace, then the person commits a misdemeanor. So again, we're bringing in this arbitrary use of, what's the word? The arbitrary use of, I'm losing my train of thought. The arbitrary use of discretion. So somebody somewhere can look at what you've done as a journalist and say, oh, what you did is likely to cause fear and panic. Therefore, I'm going to arrest you. The same language is repeated in the 2008 Act 75, the Communications Act. Okay, it says, if they are likely to prejudice life-saving service or endanger safety. Likely. So, unlike other situations where your actions would have to actually cause harm or loss before you are considered to have broken any law, as a journalist, if your actions are likely to cause harm or loss, you can go to jail. Just because someone says it's likely. Nobody has to be harmed. Nobody has to lose anything. But just because someone says your actions are likely to cause it, you're going to jail. So for me, I think that this idea that as for journalists, when they get it wrong, they are criminals. But everyone else, when you get your job wrong, there are administrative processes, there are civil processes. I don't think that is equitable at all. And if we are...
I think Musa's point in his presentation, he talked about, and it's a very critical point you raised, right? It has to do maybe in our legal tradition with the way we have construed these limitation clauses, right? I think we all accept that rights are not absolute. But what we have not also come to accept is that limitation clauses are not absolute. Restrictions are not absolute. In many other jurisdictions, criminal sanctions would not be attached to the kinds of violations you are talking about because they'll be considered disproportionate. So the proportionality test is used in many jurisdictions to weed out that kind of penalty against a speech violation, right? And it requires a certain jurisprudence to back it and a certain shift in the way in which, within our legal tradition, we understand these concepts. So it's a very important point. I think that it's something that we need to work at a little bit more. Constitutional language can help. So the Kenyans, when you look at their limitation clause and look at the one in South Africa, they are very deliberate about how they've worded those clauses because that's where the mischief is. It's the way in which limitation clauses are worded is where the threats to rights always come from. And in fact, I agree with Musa that our wording, the way we have formulated ours and the language we've used is not very neat, right? But definitely criminal sanctions attached to speech violations of the kind you are talking about likely to cause most places would not stand because they'll be considered totally disproportionate, totally vague, and not putting you on notice enough as to what you've done wrong. But we, unfortunately, haven't, sorted out a lot of the 1960s laws. Would not survive in most places, but we still have them. So maybe clarifying the language might help, and this is where I think maybe you could work with GJA and the other to help us with, just do a comparative search, look at how these things are regulated in other democratic jurisdictions. Look at the language in Kenya, how it works, language in South Africa, language elsewhere, and see if we could actually not do a better job of crafting the limitation clause. That is where most of the mischief is when it comes to rights. Because they are almost, we assume that they are absolute. They too are not absolute. You know, limitation clauses actually must be couched in such a way that they do not do more than is needed to cure the harm they want to cure. The right must always be left intact. Just cure the little mischief that you want to cure, leave the right alone. But we haven't gone that, you know, and so I think it's a very important point, especially the criminal sanction bit. It's a very important point.
All right, I'll wrap up with this just so that colleagues can also have the chance to contribute. These are 2 points made by my colleague Kojo, who had to leave us. His first was that he agrees with calls for a fund to help support investigative journalism, but he thinks it should be even broader and should be available to support all kinds of journalism. We say we are the 4th estate. Well, the other 3 estates are funded. So in order for us to actually be able to play our role of being a check on those 3 estates, we need to be funded. And so the idea of creating a fund by law, which people can apply to, you know, when they have particular investigative projects or journalistic projects that they think are in the interest of the public, can apply to it and have a panel, sit on it and consider, you know, their viability and then approve or disapprove accordingly. That's a suggestion made by Kojo.
You should talk to the guys at IDEC, Emmanuel Akwete and others. One of their proposals is to have a fund, a public fund. They didn't say state fund, and they make a difference. A public fund to support democratic institutions, right? And so it's not specific to political parties or media, but it's a public fund. And the idea of the public fund as opposed to state funding is that the sourcing can come from all manner of sources, including private sector and the like. But they have an idea there, and maybe if you want to associate with that, you could talk to them and look at how, you know, media, the 4th estate fits, or even just specifically investigative journalism alone fits into that framework if it works. You know, so maybe you should cross-check with them and see if you can align yourself to that idea. I think it's an interesting proposal.
And finally, Kojo and I agree with Prof. Karakari that if we are to set up some sort of pre-qualification for journalists, we will walk into all kinds of difficulties. But Kojo's suggestion is that, well, if we can't do a pre-qualification, can we then have perhaps something like the test that people must do in order to get a driver's license? So you don't need to have a degree to get a driver's license, but you do need to understand the do's and don'ts of driving. Is it possible to set up some kind of qualification to establish those who are licensed to do journalism? Well, not like, we can't use the word licensed, but yes, those who have passed the test to do journalism as compared to those who have not. You know, some demonstration of the general principles, the ethics, maybe some sort of test that involves scenarios, whether we want to make it oral so that people don't have to be lettered in order to pass it. But is there a way of considering the possibility of establishing some testing criteria? We're doing it for teachers, we're doing it for lawyers. Is it possible to do something, to fashion something for journalists? That's my Kojo's suggestion. Thank you.
We have lunch coming up shortly. Mr. George Sapon, Executive Secretary, Media Commission, he's here. We'll have him take his turn before lunch. Then we will, I think it's almost 2:30. Yeah, it's 2:35. We should have lunch. It's usually 2 o'clock, but we've gone over by 30 minutes. Let's take the comment from Mr. George Sapon Then we'll break for lunch and come back here around 3 o'clock, around 3:30.
Thank you very much, Mr. Chair. First, I am very impressed with the level of discussions and the commitment we bring. But from a regulatory point of view, the problem is much smaller than the way it's being thrown out. In regulation, we call it scaffolding the stage. It's like you have a stage play, the lights have gone dim, and instead of fixing the light, some people are standing up, others are standing on chairs, others are now building scaffold. In the end, everybody gets crowded on the stage instead of just fixing one small bulb. From our side, everything that has been said is true, but the problem is not as unimaginable as it is presented. And let me start from Sule. Sule, the point about LI 2224 in the Supreme Court judgment, when you point out that what everybody has said, that there was a provision that required broadcasters to bring their content to NMC there is no such provision in the law. And I encourage everybody to go look at the law. The court said so. There is no such provision in the law that broadcasters had to submit their content to the commission. It was on social media that this commentary came. I'm really encouraging everybody who is here to look at LI 2224 again. There is no such provision. The next thing that I want to point out, again, the comments that have come regarding them are important, but I still want to draw attention. The two provisions that 208 under the Criminal Offences Act and the Section 76 of the Electronic Communications Act, these are not media regulations. These are not media provisions. Section 208, you will find in the criminal offenses of almost every democracy. It flows from a major US Supreme Court decision by Justice Oliver Wendell Holmes when he talks about the clear and present danger test of speech. It relates to certain situations where speech is so immediate and the danger is so imminent. So, for example, political rallies, public preachings. So if you are in Nigeria, for example, in a very tense religious environment, and somebody set up pulpit and is attacking Muslims, those are the laws that would be used to regulate them. It is the same kind of rule that in a multi-ethnic society that there is tension if somebody sought to attack another tribe. So those rules are there. The problem with us is that because our media regulatory rules are weak, when governments come under attack, that's where they rush. These are very important provisions that sustain public order in almost every democracy. I do not have any difficulty at all if they have to be repealed, but I need to be honest about why those rules exist. With regards to Section 76 that Tanko spoke about and Kojo spoke about, these are anti-piracy laws. They have nothing to do with media. Again, it is the misapplication that is leading us there. And I really want to take my time, Mr. Chair, with your permission, to read for all of you to see what this is about. This is what the law says. A person who, by means of electronic communication service, knowingly sends a communication which is false or misleading and likely to prejudice the efficiency of life-saving service or to endanger the safety of any person, ship, aircraft, vessel, or vehicle. You understand? Anytime people read, they leave these important elements and settle on false communication. Anybody who has looked at the piracy operations around the world, what the pirates do is to set up communication systems that misdirect the ships to the danger lines. So these provisions exist as anti-piracy provisions in almost electronic communications provisions around the world. Again, it is their misapplication here because the state lacks regulatory rules and therefore they run there. Again, I do not worry at all about whether we are calling repeal or amendment or not, but we need to understand what they are in order to be able to deal with what we want to deal with. Now let us come back to the substantive question of broadcasting regulations and the Constitution. This is where the problem is. And it has something to do with all the questions about NMC and the NCA merger or otherwise. Around the world, there are two ways of regulating broadcasting. You may have a system where the technical parameters and the content parameters are regulated together. When you have that, we call it converged regulation. So the law will have two elements: the technical rules about frequency, transmission, and all that, and what we call the behavioral rules, which is about the content part. In some jurisdictions, there could be a third element, which is on competition, but it depends on the nature of the economy. All around the world, two elements will be there. The question whether you put them together or you separate them is a question of policy. So 80% of the world have non-converged regulatory systems. Just about 20 of them have converged regulatory systems. So Ofcom, FCC, ICASA are converged regulators. Most of the others are non-converged. And the way we explain it is that somebody is regulating frequency, somebody is regulating the content. So look at it like a typical road situation where let's say, or let me even limit it to importation of vehicles. Customs may allow you to bring the vehicle in, but how you drive on the road depends on what DVLA says. But once you are on the road, your behavior is regulated by the police, not by DVLA, not by customs. So the frequency issues do not have to be mixed with the content issues. In some jurisdictions, you can do that. So in Ghana, the government made the policy to have a non-converged regulatory system. So we created the NMC, we created the NCA. In terms of legislation, NCA has all the rules that we need to regulate the technical parameters in the Electronic Communications Act and its accompanying regulations. What is lacking was for us to develop the accompanying content regulatory instrument that will address the behavioral issues. So it is this simple. So what did the NMC do? First, there's a proposal to have a broadcasting bill. At the initial stages of the development, Prof. Kakari is here. I was very lucky as a young expert following them to have been part of the beginning. We considered ICASA, we were looking for an African example. And so we modeled it on ICASA and the legislation in South Africa. What we did not know at the time was that ICASA was a converged regulatory system, but Ghana was a non-converged system. So we put together a draft that is a converged piece of legislation that we are seeking to pass and enforce on a non-converged regulatory system. So each government, as they came and they began to interact with people at ITU, they discovered that it was not the right thing to do. But because of the prestige of the authorities behind the law, nobody had the courage to say, I won't do this. So that law has been driven more by the prestige of proponents than by the force of its logic. So any government that really understands the two things sees that this I can't go forward with. But nobody is having the courage to say this. So what did the National Media Commission do? We said the broadcasting bill has two elements, the technical parameters, the content parameters. The technical parameters in the Electronic Communications Act is far superior to the ones we put in this broadcasting bill. So let us leave the technical issues alone and let us pull out the content side of the bill and proceed to pass it. So that is what was passed as LI 2224. So every provision that the court said is unconstitutional is in the current bill of the broadcasting law that we are still dealing with. There is no provision in that law that is not in the broadcasting bill. There are only two things we put in there. One is that under the current laws, if you go to the Electronic Communications Act, the offenses that are created, the owners of the networks, we call it safe harbor. They've created safe harbor for the owners of the networks. So if, for example, you use MTN's network to misdirect a ship, MTN is protected by the law. Then you, the person who did it. Because they are trying to apply it to broadcasting, what it means is that if they apply to speech issues, then the journalist who makes the speech is the one who will be held liable, and the broadcasting station would be exempted. We decided that if we are going to make regulations, regulations must apply to the company instead of the journalist in order to avoid a chilling effect. Quickly, let me explain that when you make regulatory rules, you have three options: to place liability on the journalist, to place it on the company, to place it on the directors. In our work, we say that regulations that place responsibility on the journalist create a chilling effect. So in this law, we shifted the responsibility from the journalist to the company. So if you look at LI 2224, there is no offense at all for a journalist. It's solely on the company. So for us, it was okay that Giba responded because they knew what the game was up. We were expecting that GJA would say, in that case, our members are the ones who will suffer. But GJA was quiet. That is fine for now. Going forward, the issues, as I've explained, are not that complicated. We can let the Electronic Communications Law stand dealing with the technical parameters, as is the case everywhere in the world. Then what we need is just to have the accompanying content regulatory instrument to accompany that. If we are going to do that, there are constitutional issues. The first constitutional issue is the mandate of the NMC as outlined under the Constitution. If you set up a media regulator, there are three things regulators do. The regulator is to set standards for the industry. They are to set up monitoring systems for the industry to monitor the system, and then they are to enforce the rules. If you look at the Constitution, the Constitution's mandate for the NMC must follow this pattern of clarity. There is no such thing in the Constitution. So when you see that the mandate of the Commission is all over the place, that is where the problem is. If we think of the National Media Commission as a media regulator, then the functions of the Commission should be framed in regulatory terms. Then the last issue that I think is of concern that needs to be addressed in the Constitution, if we are going to keep it the way it is, would be in Article 167D. And I want to quickly read, Mr. Chair, and to point out where the problem is. In 167D, it says, the Commission is to make regulations by constitutional instruments for the registration of newspapers and other publications. And now, listen to this carefully. Except that the regulations shall not provide for exercise of any direction or control over the professional functions of a person engage in the production of newspapers or other means of mass communication. This provision is what the Supreme Court says. Because the law has said this, the Commission cannot seek to deal with anything that has to do with the professional functions of journalists and the media. Let me be sure. Exactly. Exactly. So both of them. If we think that the National Media Commission should be a media regulator, then we necessarily need to address these provisions. In addition to that, we need to create a mandate for the Commission that mimics the three core functions of a regulatory institution: standard setting, monitoring, and enforcement of standards. Thank you very much, Chair.
Thank you very much. Can you reduce all this big English to a submission for the because this is
If it has to be written in a Fidasi,
I mean, for an efficacy man, your English is not bad at all. Please give us a memo from the Commission dealing with this issue, the 167D and 173 issues, and then delineating the standard setting, monitoring, and enforcement powers. Because I think that is the elephant in the room, and if we can sort it out that way, that would be extremely helpful. So if you don't mind, our lunch has been ready for some time. The secretariat staff has been hustling me out there. We can go out and have our lunch, and then we come back. We have up to like 5:30 to complete. So please, let's take a lunch break, come back, and have enough energy to discuss more. Thank you. lovely afternoon of good insights, very useful for the task that we have been assigned. So thank you all for coming and for the spirited conversation. It's always good to get people from the industry or the profession to share their exceptional insights with us. So thanks a lot. I think we'll continue with the conversation. I think the earlier ambition that we could actually talk about other things beyond the media is probably an ambition we have to forget about for now, because it appears that talking about the media alone, there's plenty to talk about. But if there's time before the close of day for you to share your views on other things, feel free. But for now, I think there's plenty of stuff on our plate already about the media and the profession and regulation and ownership and all of those things. So I think we'll stick with that for now. So, gentlemen at the back, please reintroduce yourself and then proceed.
Thank you very much. My name is Redwan Karim Dini Osman. I work with the EIB network, GH1 TV and Star FM. I actually have a number of concerns that I want to raise, but I mean, following the comments made by Mr. Safon, now I don't even know who to direct, those concerns to. My major concern has been how the industry polices itself. And I think Professor Kakari and others spent a lot of time talking about it. But the first concern I want to raise has to do with the growing trend of influencers. We are seeing people becoming celebrities overnight, and they have numbers. You know, some of them have more following than the traditional media houses. And we saw in the build-up to the election that a lot of the politicians were sending their content to the bloggers and to the influencers. Now, the danger with that is that a lot of these bloggers and influencers don't have a mechanism of fact-checking and, you know, establishing the appropriateness of the content that they are getting. A lot of them are looking for the money, and so they get the content and they put it out there. How do we reimagine a situation where we bring all these bloggers and influencers under one umbrella, where they get some guidance on how to, you know, work closely with the traditional media organizations, and also how to, you know, fact check some of the things that they are getting before they put it out there? Because at the end of the day, if they put information out there which is erroneous, people would consume it, and it frustrates our efforts as media houses to be able to tackle issues around misinformation and disinformation. So I think it is in our interest to find a way that that sort of collaboration would take place. Then secondly is the issue about watershed. We know that within the broadcasting space, we have what we call the watershed period, which is the time that certain programs are supposed to take place so that we don't expose children and minors to adult content. But what I have also seen is that these programs take place late at night, but in the morning, they are all over social media and they are being shared. So what is happening is that because people stream the programs at night, they leave the recording and it is everywhere and it is being circulated on various social media platforms, and a lot of young people who are not supposed to have access to these content are being exposed to them. So how do we find a way to also deal with that? Then I also agree with a suggestion by the Director General for the Ghana Broadcasting Corporation that we need to have a lot more radio stations. And I realized that Mr. Suleiman Abrahima said, well, you can't make the argument about the language because there are a number of radio stations, but we should also be interested in exactly what the other radio stations that he talked about are doing. Because if the idea is not public service, then it becomes problematic. Because now there's a lot of fascination about fighting this and misinformation online. And there is a lot that is falling through the cracks offline. And it is these radio stations that are holding the fort admirably. So being able to, properly position the state broadcaster to be able to make sure that access to radio is, is enhanced. I think it's very important. Then the final one I would want to talk about is it's also the issue about content. So for instance, you have a major newspaper capturing or doing coverage about a story involving two politicians in a sex scandal. Then they capture the politician in a suit. Then they look for the female politician in a casual outfit, and already putting the woman in a certain light, and nobody talks about it. We have all these radio stations in the Ashanti region that are, have programs meant to tackle domestic violence and abuse. And they bring sexual assault survivors and victims to their studios, and they are asking them very salacious details about how their abusers undress them, the sex positions, and they are making fun of it. And these videos are being circulated all over the place, and people are laughing. Instead of honoring the dignity and the bravery of these women, these things are happening, and they are not being talked about. And now that the NMC has made it clear that they don't exactly regulate the professional conduct of journalists, I don't know who to direct these concerns to. So I think these are some of the issues that I think we can, think around and see how exactly we can get the Constitution to address those. Thank you.
Thank you. Brother George.
My name is George Chumesi, and I am an entrepreneur in the media space, basically focusing on digital media and also the academics in terms of research and development. And my background, just for context, is that I work, or I'm a fellow with the Shorenstein Center at Harvard, and have had access to the process of the evolving American landscape and how that in relation to this conversation may apply. So from a constitutional framework, I've heard a lot of very positive things said, but I think the framing perhaps has to be, I'd like to make some suggestions with reference to the framing. First of all, the concept of public service broadcasting is not relevant anymore. It's public interest media. And public interest media takes into account the new technologies. The concept of public interest therefore becomes public good. That's number one. The second is to do with the law. The law in terms of how, from a constitutional framework or framing perspective, media is addressed. Media, in terms of public interest, has two facets right now. It's got the digital governance matrix, and then it's got the network society. The network society has fundamentally taken over all forms of old traditional media in terms of how content is distributed, the infrastructure that drives content, and more importantly, how it's funded. I think in framing this new constitutional ethos that you're considering, perhaps you should see Ghana as potentially the bridgehead for the whole continent, because this conversation is not really happening anywhere else in terms of media on the continent. Take, for example, Prof. Kakari, you bear me out on this. Take, for example, the Ghana Broadcasting Corporation. The problems that it has are the same problems that the South African Broadcasting Corporation has. The same problem that NTA has in Nigeria, and the same problem KBC has. So fundamentally, the model in terms of how the colonial system worked and how media was passed on does not work. When you look at Graphic Corporation, Times Corporation, they are not breaking even without subsidy. So reframing the constitutional ethos that you are considering, what we must take into consideration is that our forefathers, for a reason, made sure that the Constitution would protect media. And that's what you refer to, say, as the fourth estate. So the reason for media is to develop the mind, to break down barriers, and to create cultural sensitivity. So when you look at, for example, the Africa Continental Free Trade Agreement, it's not going to work without public interest media. So Ghana's role has to be perceived from what you're doing as leading Africa, so that the work you do will entail or lead to a public interest ecosystem which leads the continent. Like, you've got the Africa Continental Free Trade Agreement, you've got the AFDB, you've got Afri-Exim Bank. You need a system, we need a system which looks at media in terms of public goods. So a lot of the issues that have been raised here, when you look at what a network society definition is, it's simply infrastructure. Everything from undersea cables to wireless systems is all infrastructure. Then you look at logic. The logic applies to things like domain names, things like root services, service and all of that. They look at the economics and societal layer. It looks at users, education, apps, social media, what misinformation and all of that. So we've got to look at it holistically. The final point I want to make is, Professor Amin said the government should consider naming Ghana as the 2015 7th June deadline. The guys in Switzerland set up, I've forgotten their name, but it's like the body. ITU set up. The reality is that it's not true. You need a digital media ecosystem in order to say that your country is digitally savvy. We don't have that. The opportunity, however, is that according to Google and IFC, the industry this year, nobody has tapped it, but if we had tapped it, it would be 180 billion US dollars this year. The report is public domain, so there's money to be made. All this thing about funding and public fund, the government hasn't got the resource to fund anything to do with media. But if you look at media and public good as a commercial opportunity, as Professor said, and public good within the context of taxing the commercial opportunity, then you have a framework which works for Africa, which works for Ghana. And if it's done well, based on the revenue streams that Amazon, Facebook, Apple, Netflix and co are doing, it's quite possible that if digital media is properly applied, it would make far more money than cocoa and gold in Ghana. Thank you.
Thank you. Is it also possible to share these insights in digestible form for people like us, so that we can have your insights in a submission, a memo for the commission?
Yeah, I've got a lot. If I get an email address, I'll be happy to send you data.
Good, thank you. We'll stay with the left for a little bit. You are closer. Let me hear.
Thank you very much, Mr. Chairman. My name is Jerome Kuse.
Jerome, it seems you've gone ahead of me.
I nominated somebody here first. Then we'll come to you next.
Thank you, Mr. Chairperson. I want to reiterate the point that Prof. there had raised, Ibrahim Tanko, on the vagueness of some of the wordings that, for those who don't know me, my name is Kemini, I work for Media General. The vagueness of some of the wordings that impede our ability to get information. I can't begin to count how many times the excuse of national security, the excuse of public, and in fact, in the wordings, we have public morality as well. Who is determining all that? So it's important that there is clarity on those things. And we have examples to back that. The Public Order Act. There was a lot of times prior to very recent history that the police determined whether or not people should demonstrate. Public pushback, legal pushback, taught us that indeed they had to even go to court to make a case for why or why not you can demonstrate. I think it's the same issue that Ibrahim Tanko is raising, and it's really important for us from a practitioner's point of view. I go to the point on definitions. When we look at the phrasings on media freedom, on what we are able to do and what we are not able to do, there is no clarity on whether the press and media is referring to corporate bodies or individual journalists. And in fact, if you look through, it's only at, I think, 171 that the issue of journalists is raised. And so it's important that we redefine, press, media, individuals, so that the focus then is on public, instead of just, something being said. The focus is on publication. So everybody now falls within the net. It's just those of us who have gone to school and trained as journalists or trained on the job as journalists. Then I would dovetail into regulation, because there's been a lot of calls, let's regulate, let's regulate. Now, when we begin to see the issue from publication point of view, rather than a journalist point of view, or the news media point of view, or social media point of view, and realize that with the current system that we operate, where I can go to, even without being a journalist, I can go to social media and put something up there, and someone else will consume it, we will all become responsible. Then we'll start to see that the issue about regulation will not only be about what the journalist should come and say, but for you too, you as the person, you will start to think about some of these things. So I think the focus should, when discussing and wanting to rewrite those aspects of the law, the focus should be on publication. It should be clear whether or not we are looking at the corporate body, the press, or we are looking at individual journalists, or perhaps even all, which is more important in my opinion, that we look at all of that, and individuals who publish items, so to speak. That way we are also able to bring in our friends from new media, because as we have, as we have admitted, we do not have any provisions for our social media friends. I believe it will deal with that. So that's it on definitions on press and media. I also want to say that it's important that we tread cautiously when we call for regulation. I understand the need to keep the airwaves sane, but we also need to work in such a way that we don't end up chipping away some of the rights, journalists, some of the rights that we should have when it comes to freedom of speech. And again, I'd want you to note that I didn't put it just at the doorstep of the journalist, because at the end of the day, when you also put yourself in the circle of publication, you realize that the freedom of speech is not only for the journalists to do their jobs. It is also so that you are able to do. Now, when we begin to say that let's regulate, let's regulate, let's regulate, then what happens to my mother at home? We should start to ask ourselves that question. So let's broaden it. And again, in my opinion, you would see that when we talk about regulating, it will lead us down the right path. Indeed, that's what I'd like to say on regulation as well. The issue of licensing, which the chairperson raised, I don't think has been properly dealt with. The Constitution is clear, and I think that, Prof, you read something from 1623. The complete of that has to do with the licensing, and I don't think that when you ask the question as to whether or not that provision in the Constitution had outlived its usefulness, I don't think we were able to get to the bottom of that. So, I mean, for those of us who have the legal brains, perhaps we could do that. Because again, like Sulemana Brahima pointed out, it is the provision in that led Rekrubobe to establish Radio Eye. And in fact, in very recent history, we have seen him also make the point that media houses do not need licenses to operate in this country, especially on the back of some media houses that were closed because their licenses had expired. So I think it's important that we look at that as well. The DG of GBC is not here at the moment. He mentioned issue of tenure for DGs, but much more important than that, I think we should also look at Article 169, which is on the appointment of editors. because editors are supposed to be gatekeepers in a newsroom organogram. And so when we have that the appointment should be done in consultation with the Public Services Commission, it would seem as though it was a cock and cap measure that had been put there. Because if I cannot rise through the ranks and become an editor in state media or in public media, and my appointment needs to be determined in consultation with an external body that is also very close to the government, it creates a counterintuitive, outcome. Because then where is the independence of that? People should be able to rise and become editors as gatekeepers so that they can follow it would ensure the independence of the state or public media as we're talking about it. So I think basically those are the things I want to outline at this time. Thank you.
The man who hijacked it the first time.
Thank you very much, Mr. Chairman. My name is Jerome Kuse. For the past 12 years, I've been running a public interest finance and economics blog. I want to say a few words for social media because I believe today's engagement is about the media and the social media community. And I consider myself a member of the social media community. The first thing I want to say is that I believe social media has an internal mechanism for regulation. I know sometimes we may think that social media is the worst purveyor of false news and making stuff up. But the thing about social media is that whatever you post has an immediate reaction which people see. So you put something out, people can comment, people can call you out, and all of that is available to the public. And that is something that traditional media does not necessarily have. So even if we believe that social media people are, let's say, a bit careless in what they put out, the system allows some kind of self-regulation and fact-checking. And now with artificial intelligence, people are able to ask third-party applications to verify what somebody has put out there. So we shouldn't paint social media as this wild platform, this unregulated space, as compared to traditional media, because I'm willing to say that looking at the current media landscape, social media is on par, if not better than traditional media in terms of self-correcting and regulating itself in terms of the information we put out there. The second thing I want to say is that I believe we need to start looking at digital assets and making it part of state assets. I'll give you an example. If there's a social media handle called Ghana Presidency, then I believe that there should be things in place. There should be a system in place that ensures that this handle is consistent across all governments, that there is a proper procedure through which these assets are kept and these assets are transferred from one government to the other. And this is a very critical step towards checking false information. Recently, the account of the president was hacked and some cryptocurrency, whatever was put on it. I believe that it's important that we consider these accounts as state assets and put in some kind of mechanism to not only protect them, but ensure that the information on there can be archived. The information there, the details of the accounts can be transferred from one government to the other. And so when people are looking for direct, verified information, we all know the handle which we should go for. We all know the handle that we should go out to look for that information from. The next thing I want to talk about is the fact checking. Already, people are using third-party fact checkers. And I believe that as part of public or state media, we should fund fact-checking organizations. In fact, there should be an official one if possible. For example, you argue with somebody these days. I was having an argument with somebody, and the person went to bring me information from ChatGPT to say that what I was saying was wrong. And ChatGPT is essentially the independent arbiter. But that is not the case. That is also an opinion. So I believe that it's important the state resources fact-checking institutions or have an official fact-checking institution as part of the public interest media that it is carrying out. My last submission, it doesn't have to do with social media, but it has to do with young people in general. I overheard, I'm not a lawyer, but I overheard the thing about some institutions that are described in the Constitution, not necessarily named. And I was asking my lawyer friend whether there's any association of students that is named in the Constitution. So if there's an association of marketers, is there an association of students? And coming from someone who was very active in student politics, it has been sad to see how weak the student front has become. So I want to suggest, is there a way we can have association of students in the Constitution so that the state would take an active interest in preserving the student front as an independent body that can also make appointments, or they can nominate people to be part of whatever constitutional functions are required? That's my contribution. Thank you.
Thank you. I think we can go back to the right, and then we'll come back. Oh, really? She was. Her lady is speaking for the lady. So, okay. So, please.
Thank you, Mr. Chair. Good afternoon, everyone. My name is Gloria, and I work with the Ghana Independent Broadcasters Association. I felt much had been said about regulations and what we would like to see in the media space. But after the submission from the lady on my right on the lack thereof or need for licensing in the media industry, I felt I should something. The role of the NCA, as also advised by the International Telecommunications Commission, is to manage and regulate frequency in the country. And so by their role, by what they do, so long as the frequency is being used, they have the mandate to manage it in the way that is for the good of the entire country. Because these frequencies that are in use are not only being used by broadcasters, but the airlines use them, the Marines use them, security forces, telecom, everybody uses them. So the NCA comes up with modalities on how to manage these resources. And so for us, the broadcasters, and in the media, what we've been saying is that if there could be that convergence, as earlier alluded to by Prof, of the role of the NMC and the NCA, because the NCA law in itself already says that they should be working with the NMC. So why don't they then come together to regulate that broadcasting space where the authorizations will be given? Okay, that is our submission. And I believe we already presented something, but as I was speaking to Prof a little earlier on, I promised sending him more material so that he could study to see whether it was relevant to the work you were doing. Because a lot of submissions have been made, and the media, we've come together to work on all these things. That is the GJA, the printers, private publishers and online Publishers Association of Ghana, and GIBA. We've been coming together to work. At a point, we also work with the Media Foundation for West Africa. So it's whatever position we present, it's unified position, sort of. So thank you, Mr. Chair.
Thank you very much. It's good to hear that you have already presented something, but you are trying, you intend to augment it even
Right.
further.
Thank you very much, Mr. Chair. A couple of things just for the preliminary issues, just like Jerome raised about
Reintroduction.
Okay, yeah. My name is Kwiku Asante. I work at Joy FM and Joy News. So Jerome is of the opinion that we must write into the Constitution, say the student body. I think that we must take away every private association from the Constitution, because the Constitution itself provides for freedom of association. So that why is the Ghana Bar Association provided for in the Constitution? So that when there's an appointment onto the Judicial Council, then you provide for that. So next 2 years, if some lawyers find themselves and found another association, that association does not have any representation, say, on the Judicial Council, for instance. So if it is possible, we must do away with every private association, strictly speaking, from the Constitution, totally, so that, for instance...
Then you have every state body in the Constitution membership will be constituted either only by public officers or by persons chosen in their individual capacity, no institutional representation.
I think there may be a way to do that. So that, for instance, in the Constitution, there will be places where the Constitution will say from faith-based organizations. And these faith-based organizations sometimes find ways to put themselves on some of these places, so that in certain university governing councils, in those statutes, sometimes provided for teacher unions, NAT, CCT, NAGRAT, find a workable way to put themselves on some of these boards. Because the problem with legislating onto the Constitution, the supreme law of the land, say GBA, means that GBA almost become a constitutional body of a sort, and it almost become a monopoly of an association. Others can't go out there. I think that must be dealt with. And while I have the floor still, in the last few days, we have been doing a lot of reporting about whether or not there's a power vacuum in the country. Whether or not the president having traveled, the vice having traveled, the Speaker of Parliament also having traveled, whether or not there's a power vacuum. And a lot of mention have been made in the Supreme Court decision in Asare, where traveling out has been said to be inability to perform his function. So that yesterday, the president was signing memorandums in Ivory Coast or Togo as president of Ghana. And then if the speaker was around, the speaker is the acting president. Do we have two presidents at the same time? Especially in this modern day of communication. And so some of these things, we need to look at it. If the court is not willing to reverse itself, perhaps the wording must be dealt with in the Constitution as a way of dealing with that. Coming into the substantives of the media conversation, I believe one of the things we can understand is to broaden a little bit of its scope. So that, for instance, when it comes to authorization in terms of the line census, you can take the frequency part from the National Communication Authority. Because NCA, as we've come to know, has been focusing on other matters with very little emphasis on media and the frequency authorization. We know that it become a platform for politicians to be taking it. I report from Parliament, and I know about half of members of Parliament who own media houses all over the place. And so when you lose, now you can't get access to authorization unless you have some of these connections. So the National Media Commission, given the way the Constitution has framed its powers, if we were to add the frequency authorization bit, just that bit from the National Communication Authority, instead of, say, merging it, then National Communication Authority can focus on what I believe they've actually been over-focusing on, the telcos and other business. They can focus on that. And the National Media Commission, which actually has specialization in media issues, can actually focus and deal with that. I believe that is one of the things we can do. Again, in earlier remarks that were made by one of us here, talked about whether or not the NMC must have powers to summon people and to compel attendance and all that. I'm a bit divided on that because of the current status of the NMC as a body. so that even courts where they can compel witness attendance, for instance, can you forcibly hold someone's hands and push them into a dock and ask them to do certain things? So the NMC will be able to proceed and take certain actions. We must design a frame, for instance, that if the NMC made certain determinations, it can be appealed to, say, the High Court, for instance, so that persons who feel like the National Media Commission may not have a certain level of expertise to deal with certain issues can have a second forum that they can go to. So I believe if you do that, that would be great. One other thing that I think is very crucial going forward, the TV license issue about the state broadcaster. Although it's usually called the state broadcaster, it appears to me to be government broadcaster. So that the focus of GBC, for instance, the Ghana Broadcasting Corporation, because of its financing model, has become a government broadcaster, because the budget of GBC, as we've come to know it now, prior to the new president striking off the information ministry, the budget went through the information ministry. So that level of political control still exists. But if you go to Germany, for instance, where the TV licensing regime really works well, or in other European countries like, say, United Kingdom, if we legislate, say, into the constitution or into other subsidiary legislation as to the TV licensing fee, then the GBC and others become proper state media. And then we can, for instance, look at the composition of the board. We can have a designation for it. Well, in Germany, for instance, they have representatives from political parties that have a certain clout in parliament, for instance. And then you can put on a lot more diverse persons. Because as GBC still exists in its current frame, there is still a lot of maneuverings that politicians can do if they want to control it and do all of those things. So I think let's do that. And then there's the bit about using false news laws to actually strangulate journalism in the country, so that in the last 2 years, Bobby Ansah was picked up because he said the wife of the vice president owned this land or that, and said that is false publication, causing fear and panic. So that my understanding of some of those rules as they exist in the criminal code and other such laws are that, for instance, if I went to the stadium and whilst we are all watching the football, I shouted, "There's a bomb," then we all rushed out. That's false news. And it led to injuries, it led to death. In my opinion, that is what some of those things are supposed to deal with. Not just like the vice president owned this land, the president owned this. If it's false, I can take it on in the way without police officers going to a media house pushing someone out. The only challenge is, the Constitution, there's a big limit on what we can put into the Constitution. The Constitution cannot carry all the ideas. But if we were able to put in place some of these principles so that all other subsidiary legislation will come with that, so that in the US, the First Amendment, the 14th Amendment, these are things that have been written thousands of years, hundreds of years prior. But still, because they have a certain frame that encapsulates some very broad ideas, and the other thing follows. The other thing is that, and that's why I conclude, is that we can write very beautiful laws. The problem sometimes is the people who will implement it or the people who sit on it. Or because, the idea can be as brilliant as possible. If someone decides that they will represent the law in a certain way, it just wouldn't work. So that, for instance, and this is not a disrespectful criticism of the Supreme Court, I struggle to see how, with due respect to my lords and my ladies, how someone sees, because if you look at it goes back to the provision Asari case, where the president travels or is unable to perform. Because the moment you go into the next section, the next clause, it actually clarifies. It's not like where the president travels or is unable to perform his functions. Because those two things are distinguishable, you can separate them. So if you have all the brilliant laws and you have I just say, okay, I'm doing purposive interpretation, and then he'll do something else with the law, or politicians will always find a way to deal with it. The way in which the politics is done in the country also contributes some of those things. So you're doing a great work, probably come out with a report, there'll be a white paper, the process will be done, and then ultimately we get a very beautiful law, we put it on the books. But if the implementation and the conversation around how things are implemented are not really properly done, then I guess we'll just come back here 10 years down the line, we'll say the Constitution has a problem, let's rewrite it, let's do this, let's throw it away, and then we'll find a way. And then just before I was willing to hand the mic, I just got this brief.
The last one.
Yes, this one is truly the last one.
We are done.
Okay. Oh, V-mates, if you give me just one more. V-mates.
There is no V-mates
okay.
matter.
Okay, that's fine. Thank you very much.
Thank you.
Okay.
About if the Constitution, the amendments are made and how it will be implemented, we are hoping that the media will carry us forward and they will help to disseminate our recommendation and then be the gatekeeper to make sure that Parliament passes the law which will let the process for, let's say, referendum take place and then pass legislation to give effect to our recommendation. So I'm glad that you've made that point. So please, we are asking the media to help us, to carry us along and educate the public what is happening.
Yeah, actually, I was going to say almost, it's interesting because I was going to say that it is true. In terms of implementation, the Constitution, I think, empowers us all to help with implementation in multiple ways, right? Unlike most constitutions, we have Article 2 that allows every one of us to enforce the Constitution in court. We have a Constitution that says the media have a responsibility, almost a duty, to uphold the accountability of government and all of that to the people. We have a Constitution that says the Supreme Court can change its mind if it makes a mistake. It can reverse itself. So there are a number of things in the Constitution that essentially admit that we may have operational difficulties here and there. But it's giving us all kinds of tools. We have an NCC that is charged with civic education about these same issues, right? So I think it's also because we as a citizenry have essentially abdicated and oftentimes think that the operators of the Constitution are only the public officials who must, the duty bearers are the only operators of the It's also us. Actually, we the rights holders, more than the duty bearers, are the ones who must push it. So really, even through this process, it's not just us. Once we're done, it is up to the public to follow the process, to look at the report, to mobilize around it if you support it, to say you don't like this or that. So there's a role for everybody. And I think this idea that the people who implement it are there, and they are the only ones who can spoil it. All of us can spoil it, actually. Abdication is one way of spoiling it. And, there are so many things in the Constitution that nobody has gone to court to enforce. A lot of the complaints we are actually talking about here, many of them have never been tested in court by anybody. Even people who know that there's something going on that's not proper, nobody has tried to enforce it in court. So I think it's a collective responsibility. So sometimes we say, oh, the courts are the guardians of the Constitution. Actually, all of us are the guardians of the Constitution. Because how do you expect the court, which cannot go out to fish for cases, to be the guardian of the Constitution when you are the one who can actually bring the suit? If you are not the guardian, how can the court, that is a passive agent, sitting there for the case to be brought, the one who you have called the guardian of the Constitution? It's you. You're the one who can actually activate the Constitution before the court can take notice of it and take the matter. So we need to change the way we think about these things. And I think it's a good time for us to be rethinking some of these ideas. But there are tools there for all of us to make sure that it works. I want to refer you to Article 193 of the 79 Constitution, right? the 79 Constitution created the Press Commission, which is the precursor to the Media Commission. And as we've been talking about the powers and the function of the Media Commission, I just checked to see what it was in the last Constitution. Very interesting provision here. So the function of the Press Commission shall include, right, 193D, the making by constitutional instrument of regulations for the registration and licensing of other media for mass communication. Right? Now it appears, this doesn't appear in the current one, right? So between that period and now, the formulation changed, right? And now we are back talking about who licenses, who authorizes before the NCA can issue and all of that. So sometimes, I think going back to the history, let's look at 79. If there was something there that was left out, and we think that it's actually a better formulation, maybe you could go back and look at it. I also noticed one thing in the 79 Constitution. You just mentioned NMC maybe summoning media, violators of whatever, offenders, and adjudicating some matter before it goes to High Court. Actually, in 1979, the Press Commission had its powers included investigation and adjudication of complaints. When you come to 1992, adjudication is taken out, and it becomes mediation and settlement, right? So they've moved away from a quasi-judicial kind of mode to ADR kind of mode, right? So there's something happened between 79 and 92 in the way in which we are thinking about the NMC. And maybe in thinking about rethinking again, we should go back to 79 and see if there's something there that, may be useful to bring back into the conversation. Yeah.
Yes, sir. Prof. Chair, I thank you very much. My name is Kofi Abua from the GJA. I want to take off from where Kweku landed. It is true, I agree with him. We may have very beautiful laws, but the implementation or the application of the law. So we've been talking about Section 76 of the Electronic Communications Act and Section 208 of the Criminal Offences Act. They may be good, well-intended, as George Sapon had alluded earlier, but the application, and under the regime of Dampare, we had seen how the police had used those two laws to clamp down on the media, sometimes to the extent of issues that are clearly defamatory, and yet journalists were arrested and imprisoned. So if we don't implement the laws as they are well intended, we will always have issues. And that is our fundamental issue against those laws. And then I also want to touch on Article 1623. I strongly believe that the framers of the Constitution had put that provision there because of our history. If you read the newspaper licensing law history, since it was first introduced in 1963 up to the PNDC era, that law had stifled the development of the media to a great extent, and Prof. Kakari alluded to that. So I want to believe that is why the provision was made, and it is even an entrenched clause. And in our conversation, I think we should appreciate that as of now, we don't have a licensing regime in our media space. So for the electronic media, what NCA does is authorization. A lot of the time, we throw in the word licensing, but NCA doesn't license. They give authorization. And if you look at what the NMC does with newspapers, once you satisfy the requirements, NMC only gives you a certificate. So it is not a license, and we are not operating under that regime. And Prof, I will vote for that provision to be maintained because it aligns also with international best practice that you need to have that free space for people to operate. What we need to do very well is about regulation. And I think once we get the regulation right, we'll be able to address some of the ills surrounding Article 1623. Then, Prof, I also want to talk about Article 168. And 168 mandates the NMC to appoint the chairman, and the president says, well, the proposed or the nominations you have presented, I don't like this one. Is the president influencing the process of appointment? So I think we need to take that caveat away. I don't think we need the consultation of the president. Otherwise, in my humble view, it takes a lot away from the independence of the NMC. And then I also want to go to 163. And 163 mandates the...
So you, in 168, you would take out in consultation with the president. And you would take out in consultation with the president and leave it at...
With the president, we may...
The commission shall appoint the chairman and other members of the governing bodies of public corporations managing the state-owned media, period. Just stop.
Yes.
Not in consultation.
Or we may apply what is in 169 in consultation with the Public Services Commission. My friend Kamini is not comfortable with that, but I think that is better than in consultation with the president. Then, Prof. Chair, I go to 163. 163 says the state-owned media shall provide fair opportunities and facilities for the presentation of divergent views and dissenting opinion. I am thinking that that should not be limited to the state-owned media alone, and that it should be opened up to all agencies of the mass media, because in my humble view, that provision is intended to promote democracy for the presentation of divergent views and dissenting opinion. So if that is so, why must we limit it as a function of the state-owned media? So just as is provided for under 1625, the watchdog mandate of the media, all agencies of the mass media shall at all times be free to uphold the principles, provisions, and objectives of this Constitution, and shall uphold the responsibility and accountability of the government to the people of Ghana. All agencies of the mass media. So likewise...
Isn't there a reason why there's a difference between, so the state-owned, the idea is that this is a public resource, a public facility, and we must therefore ensure that all views are represented in any conversation. You cannot just take one side. But if we allow private media with particular ideological or partisan or other kinds of preferences to operate, must we impose on them a duty to represent the other views? So you go to, let's just take an example. I don't know what party they represent. But let's say there's a radio station called Oman FM or something, and they want to push a particular agenda. As long as in the marketplace you have another station that also pushes another agenda, maybe we can get diversity at a higher level, right? You have one pushing agenda A, another pushing agenda B. So there's diversity, pluralism in the media space, but not in any particular station. Right? And you're saying that we should have station by station, they should represent all the views in that one station. Why can't we just do it at the pluralism level in terms of the whole media landscape?
Prof, I appreciate that, but
Sophie,
even
hold
the ethics of our
So
profession.
we want to, Professor Kakari wants to share some insight on that.
I think that what the Constitution proposes for the media is, as the chairman has said, a freedom for anybody to set up their media. In other words, it's replicating what ought to happen in society generally under a democracy, that everybody should have the right to their own opinion. Now, when we talk about the presentation of divergent views and dissenting opinions, sometimes we are only thinking about narrative stories and so on. But it also includes advertising. So for instance, I ran a newspaper or a radio station as for Muslims, for Catholics, and you want a Muslim station to advertise pork. Or, as has happened in recent times, there are people who hate homosexuality. There are people who defend it. Now, if I'm on this side or that side, and I choose not to accept your perspective, you are saying that the Constitution should sanction me. I think that what is the public media that should be charged with presenting this plurality of views, not private media. I don't think we can impose such structure on private media. Why should media representing NDC or MPP open its pages or airwaves to the other party? Why? It will not be, I don't think it will be democratically right to do that.
I mean, you could also have the situation in the US, right, Prof? Because at some point, I think before Reagan, the FCC was implementing something called the fairness doctrine, where all media under the FCC rules, you were actually expected, I don't know if it was required, to have a diversity of views on certain shows, right? Of course, Reagan in the neoliberal revolution just came and did away with that. But the market itself forces even partisan media to try to represent the other views. Because even Fox News, right? We know Fox is a particular, leans one way, but even Fox News sometimes, because otherwise people will tune you out. You just get only, they are forced to bring in other views to challenge yours. Oman FM cannot, must be forced sometimes to encourage discourse from the other side, or Woon to Me or Radio Gold or whatever, right? So there is a way in which the political marketplace forces diversity of opinions, even without us requiring it in the Constitution. Very few stations just invite only people from one side, right? So you don't have to require it.
That is the fairness doctrine. And also the other fairness doctrine, that even if you have a tunnel view ideologically or whatever in your media, if you say anything about me or the other side, you must allow me to respond and so on. And particularly talking about the FCC, when it comes to news particularly, that fairness rule must, for instance, somebody, let's say there is a news report about a situation, about some personality. What is the balance? What are the other sides of it? You and I know that news ought to be objective, blah, 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 blah. So that's where the doctrine, the fairness doctrine prevails. But this here is really demanding too much. That, for instance, the Director General of GBC was telling us about 27 languages. That is their mandate. But you can't ask Joy FM or City or any of the private stations, to do that. It will not. I don't think it will be fair in terms of media freedom.
Profs, I appreciate your interventions. I was looking at the operational word fair opportunity. And fair may not necessarily mean equal. In my humble understanding, something you think will satisfy all righteousness and not necessarily an imposition on you. And I'm also looking at the context of promotion of democracy. And we have also talked a lot here about media responsibility. So, and the question has been asked, what do we do to address that question or that need? So I was thinking if we elevate it to include the private media, it will also help to bring sanity into the space. I defer to you.
No, there's no difference. You are advocate for a particular view. It makes sense. We're just, some of us are playing devil's advocate. Some of us, we want to push you to explain yourself better. So.
Okay. Then I will also want to go to 5511. Prof. Amin had addressed that adequately, and Article 5511 on the states providing fair opportunity for political parties to present their programs to the public by ensuring equal access to the state-owned media. I agree with the submissions made by Prof. Amin on that. I am thinking that clause is quite vague because it doesn't even leave the decision in the hands of the state-owned media. It leaves the decision in the hands of the state. And I don't see how the state can ensure equal access in the state-owned media. So we need to rephrase that provision. And as Prof. Amin said, we need to include the enabling clauses. And I will suggest we include words like to ensure that the state-owned media have requisite logistics and funds to discharge that mandate under Article 5511. And then I will also...
So you will change state to state-owned media in 5511. Is that your preference?
No, maintaining state-owned media, but adding that they should be given adequate or requisite resources, including logistics and funds to discharge the mandate under that provision. And then, Prof. Chair, just a take on whether to scrap private associations in the Constitution or not. I'm yet to be convinced as to why that should be done. I have not been convinced about the mischief in their presence to warrant scrapping. In any event, the alternative that has been suggested may not be a solution, because if you talk about faith-based organizations, how are you then able to ensure that all faiths are covered? And would there not be instances where some may be left out?
But currently, it's even worse, right? Because currently you actually name them. You say, Christian Council, Catholic Bishops Conference, Ahmadiyya Movement. So the current formulation of naming specific private voluntary organizations actually is more exclusionary than the alternative that you think is going to exclude. Because, and I think it's really, the argument is really just, it's also maybe proper drafting, right? That a body whose existence and life are not based on the state didn't create them, the state doesn't ensure their longevity, they can disappear. You don't write them into the Constitution, right? Because assuming they didn't exist any longer, would there be a constitutional vacuum? Assuming today that the Ghana Journalists Association ceased to exist, or the Bar Association ceased to exist, what do we do with the constitutional provisions that has entrenched their membership in certain organizations? Because these are private bodies that don't have to be there at all. So the argument is that because the state doesn't control their existence or longevity, it must not impose them onto the Constitution that way. Just describe something like the body representing lawyers or whatever shall nominate 2 persons to the Judicial Council, as opposed to the Ghana Bar Association shall nominate 2 persons. So I think that is the entirety of the argument. It's not that they should be written out, but they shouldn't be named specifically because they are not constitutional or state bodies. So it's not, it's really a technical, maybe a little technical drafting issue, but the truth is that it's difficult to take them out across the board. There are so many of them everywhere.
And just to add to that, consider the fact that at the time that the 1992 Constitution was promulgated or whatever, we only had one teachers association, wasn't it? NAT. Today, how many do we have? So if we had written NAT into the Constitution, we then have a situation where the Constitution kind of then shoehorns or forces everybody into recognizing or giving primacy to one organization. If you look at GPRTU, you know, at the time of the 1992 Constitution, it was the only, you know, private association of transport owners and etc. Today, how many do we have? And so I think the point is that we're not writing out GJ or whatever, but we're saying that once it is not a state, once it's a private voluntary organization, writing specific organizations into the Constitution has its dangers. And like we said, oh. I didn't understand that. Oh. We're told to future-proof our laws, the Constitution, etc. And I think this is one of the ways of future-proofing, that in 5 years' time, we may have association of private journalists in private media broadcasting, association of journalists and whatever. Now, what do you do?
Let me give you one clear example. 79 Constitution, Media Press Commission membership, right? Listed the same way. One representative each nominated by the Christian Council and the National Catholic Secretariat. These are very specific bodies, non-state. When we come to 1992, now it's the Christian group, in parentheses, the National Catholic Secretariat, the Christian Council, and the Ghana Pentecostal Council. So in 1979, the Ghana Pentecostal Council was not there because there were so few of them. There was not a big group. By the time we get to 92, they are there, named. Now, the charismatics were not there at the time, so they are not in the 79 Constitution, but you come to, so if you define them too specifically and name them, you have excluded, by definition, all the other ones, right? So it's better to be more generic in the description of the group than to be specific in naming particular. I think that's the whole argument. It's not that we are trying to take them out. We want lawyers to bring somebody. We want architects to bring people, but must it be a particular association whose existence might change the next day or so? So I think that is really the argument, but it's not trying to write them out. It's going to be difficult to do it, like I said, because some of the provisions are entrenched. And if you take it to a referendum just to change these things, you're not going to get people probably even appearing to vote on just taking GBA out and stuff. So it's not easy to do anyway. But if it's possible, we should avoid naming specific private bodies in the Constitution. I think that's the whole idea.
I'm grateful, Prof. I think I needed clarification. I do have it now. Prof, my last point on the issue of media ownership. I think that is one great service this Constitution Review Committee will do to the nation if we are able to have a handle on it. I believe it is the source of the problems we are having in our current media space, especially radio and TV. So I don't have a specific recommendation for that, but I believe if the committee is able to deal with this issue, it will help us a lot. Thank you very much for the opportunity.
I think we need some help on that. The issue of ownership, the industry and the profession, you guys understand
How
your
do we do
industry
it
much better.
infringing on people's rights
you have
to own
give
property?
us some help. If you really think that, so people have talked about the media space is too fragmented, for example, right? There are just too many operators, not enough for everybody to make a profit. And then there is the political ownership, and people think it promotes polarization and all of those things. If these are issues, the truth of the matter is that sitting here, up until this particular engagement, I mean, Professor Kakari is there, but most of us didn't understand a lot of these issues you guys are talking about. By virtue of today's engagement, we will get some enlightenment. But you deal with these issues on a regular basis. And if you have particular ways you think this can be done, you also have the benefit of comparative models that you are familiar with from your work. If you think this is how media ownership must be done to minimize political capture of the media space, if you think it's a problem, provide us with some guidance on how we deal with this issue, right? Instead of just being like us, say there's a problem, but we don't know how to solve it. We too don't know how to solve it, right? So I think that's the challenge, that if you have, you have so many different members. You have the publishers themselves, you have journalists, you have academics who study the field, you have all of that. That's enough of a resource to give us something, because otherwise it's really difficult to sit here and say, okay, this is the problem. How are we going to prevent, media capture, a Berlusconi problem, one person owning 75% of the media space? I mean, help us with something if there is a problem.
Yes,
okay.
Sir.
So
Yes, sir.
I think you have the mic next.
Yes. Thank you very much, Prof. My name is Justice Aduboy. I work for the Chinese media, so I was even wondering why I was invited in the first place, because I don't work for a local media organization. But of course, I'm a Ghanaian, and then I've been seeing Professor Kakari and all the big guys in the media space here. I did not even think I needed to speak, but a few things that I've been thinking about. So when you look at Articles 162 to 164, you realize that, now, I was a small boy when the Constitution was came into being, so I may not know, but it looked like the concern then was more of media freedom and also how the media will help to promote democracy, hold leadership accountable. So then you are beginning to look at whether the nation actually envisages a role in mind in terms of development for media. Because when you look at state-owned media, you realize that these objectives outlined in 162 to 164, the state-owned media is also brought under it. So you begin to ask whether the country has a vision about what the state-owned media can do in terms of leading development through its discussions, through its work, etc. So I am thinking that perhaps we could put in a few paragraphs, just as we did with the directive principles of state policy and so on. We could put in some paragraphs as to what the state media that we fund should do in terms of leading in development. I can give you an example. 2014, when we went to my company's headquarters, At that time, they started using robots to read news. And they developed that with Jack Ma. So that is a kind of role that our media house played in the development of AI in China. Okay, so some of the media houses today, mimic that kind of thing. So I'm beginning to see whether Ghana has a clearly defined, role for its state-owned media to, assist in development, policy formulation, direction, etc.
When you say a few paragraphs, I think I get your drift. You are thinking, before we provide for state media at all and give them the specific, allow political parties and presidential candidates to have access to, we should have one or two clauses specifying what we expect of state-owned media, what our vision is of them within,
our development,
Now, again, when you go to 79, right, 79 Constitution, very interesting membership of the council, of the commission. The press commission in 79 had a representative from the National Development Commission, right? And of course, in 1992, it doesn't have any such representation. So when you talked about development, it appeared that there was some sense in 79, and you look at the Constitution, it's here, the press commission had a member nominated by the National Development Commission at the time. And it's not here now, right? So I think you're right that I think when you look at the membership now, it's more to do with the industry regulating itself, but they brought in the faith-based groups because of public morality issues, right? But then in 79, they had the National Development Commission as a member because they thought that they would play a developmental role. So it's an interesting point you're making. But again, if you have some specific ideas on that, that would be helpful too.
Then also, one of the things that I've also, especially when you listen to Professor Amin, and what he was saying about GBC, you have a worse situation in the rest of the state-owned media today. As we speak, some of our colleagues from the rest of the state media, they tell you, for the past 3 months, we have not received our salary. And these were institutions that were transformed into limited liability companies. They are supposed to make profit, pay themselves, and pay dividend to the state. But today, are having to fall back on central government for subvention to be able to even run. In fact, somewhere last year, there was the story about Graphic going to do an IPO. But then when you spoke to a few people, they said, no, the place is collapsing, so they want to use the IPO listing on the, so to cover up for whatever is happening. So then that brings in the role of NMC as the supervisory role they play over state media. Does that role actually include also ensuring maybe good governance practices such that, okay, like somebody was saying, media is a resource. Like Professor was saying that even to some of the, how do you call it? The self-frequencies or managed frequencies for other media houses, etc. As we speak now, Metro TV is 50% owned by GBC. Some time ago, they were going to sell Metro TV as a whole. When I heard it, I gave the story to one newspaper, and then they did it. And then before even the then Director General got to know that they owned 50% in Metro TV. But ask them, how much have they made from Metro TV till date, since its establishment? Nothing. So this is a resource they have.
Sit on the board?
They don't sit on the board.
They don't sit on the board?
No.
They own 50%, but they don't sit on the board.
They own 50% of Metro They don't sit on the board. We were sitting here.
How is that possible?
Yeah. We were sitting here when a TV station that was built as a BOT, now when the term expired, it did not revert to government, no, but was sold. And it was supposed to be transferred with not even a peso paid to the Malaysians, but then it was sold to a private entity, and the government lost it. So this is a resource we invested. National Film, GFIC, properties were given to them to run, and then now a private entity owns it. You see, so our resources, what does NMC know? Do they do auditing of the resources, the assets of state-owned media to know how much they can bring in? So the NMC should not only be, my opinion, should not only be maybe appointing managing directors, etc., for state media, but they should know the assets in there, the resources in there, so that how this can be transformed into, liquidity for these companies to be able to run themselves and make dividends for the state. Because as they expand, they employ. And then job will be created for people in the, in the country. And then that is one of the things I've been thinking about the state-owned media.
Is it something you can send us? I mean, because this goes to the point I think Professor Amin made in his presentation or in the dialogue exchange with him. It became clear that on matters of corporate structure, corporate restructuring, and all of those things, that GBC itself, and for that matter, probably NMC, has very little say. It has to go back to the minister. So even to create divisions within the corporation, to do technical work, to do commercial work, to do all of that, they are unable to do that. But in your formulation, and I think this is an interesting idea, it probably goes back to George Chumesi's point too, in terms of looking at this as a portfolio of assets that can be managed to generate, so that the NMC is not just doing editorial autonomy and journalistic stuff, but also looking at the whole state-owned media as a corporate, as an economic asset. And how we maximize the gains from. No, I think that's an interesting perspective. And maybe if there's something that any of you can help with, because we are still talking about NMC and its functions and its powers. And if you think there's more the NMC should do beyond just protecting or insulating journalism or state-owned media from editorial control, I think it's a useful input, because I think this is something that definitely did come out from Professor Amin's presentation. I'm glad that you have actually also picked up on it. So, but I will invite you, I think I will urge you to send us something.
Okay. Then finally, one of the things, and this is normal, because when you also look at the payment structures, you look at the senior management, and then you come to, still in the state media, the newsroom staff. Then you see a wide disparity between what their bosses receive. Of course, these are on contract anyway, and one is, a lifelong employment. So, but then sometimes you look at the gap, it's too wide. Somebody's monthly income, total annual income is just about maybe 20% of somebody's monthly income in the state media. And just an example I'm giving. And how does NMC come in terms of trying to ensure that, okay, we are not making so much money, but the newsroom staff also must be motivated so that they will keep running. And because recently, like Graphic, they lost a lot of stuff to the private media. I have a friend who left private media, went to Graphic. Before I realized, about 2 years ago, he went back into private media, and I asked him, he said, Charlie, is it the take home? That's what he told me. is the take home. And when I calculated it, I'm better off in the private media. By the time he went to graphic, he was taking something very good. But over the period, the value has eroded, and he thought that going back into the private media would serve him better. So some of these things maybe...
So just to follow up on so in your vision, the NMC should be something like the SIGA of the state-owned media.
Exactly.
Right?
When we are saying state-owned media,
right,
the SIGA, we used to call them SOE. So this is SOM. So the NMC should be about the SIGA of the state-owned media. That is what I believe. Yeah.
Interesting.
I'm done.
Thank you. So the lady at the back, and then...
My name is Nadidi. I also work with the EIB network, Star FM and GH1 TV. I'd like to ask, first of all, have you had any sessions on social media? Like an X space? Have you tried that? Yes.
I don't need it.
Okay. Okay.
No. I mean, my people have been trying to do...
Yes, so
They say something is called X space, and we should go there.
Yeah, I think
We'll
you
go
should.
there.
Yes, it would be great to have you there because you have a lot of the young people there. They have views that they would love to express. So,
no, they're organizing. The staff are organizing that.
That's very good to know.
Friday or Monday or something next week.
Okay.
Yeah.
Because I've seen a number of them here, but I haven't really heard them speak, or they will speak subsequently. I hope they do. So one of the things, I'm not speaking about the media, I think a lot has been said about it, but these are some of the, as they say, low-hanging fruits. Issues relating to buying state assets. Is there any way we can expressly state in our constitution that it is a no-go area for state officials? They should steer clear from state assets.
From state?
Assets.
Oh, sure, why not? I mean, there's a whole chapter of the Constitution on code of conduct for public officers.
Yes.
And when you look at similar provisions in other countries that have similar provisions, conflict of interest provisions are in there, and of course you can't sell an asset to yourself if you're part of. So, sure.
Okay.
I'm sure.
Because when you take it back to the Obechebi Lamte case where Samuel Okudzeto Ablakwa took the matter to court, and even he said he could buy it, and it's been like a free-for-all for government officials to be buying assets belonging to the state. Also, this is coming from some conversations I had with a few friends. I told them that I was coming for this program, and since all the media points I believe have been exhausted, let me talk about some of the things they suggested. It has to do with the appointment to the Supreme Court. One of them suggested that rather than appoint people straight to the Supreme Court, we should give them some form of experience. So they probably should start from the Courts of Appeal before they are elevated to the Supreme Court. So at least they will have some judicial experience. That is a suggestion that one of them did make, because they feel that 15 years of being at the bar and then straight to the Supreme Court, sometimes it feels like people just want to tick a certain box to be at the apex court. So perhaps we should start from the Court of Appeal, and then when they get the judicial experience, they go, they are elevated to the top some way, somehow.
But what about the idea that, I mean, law is more than judging, right? Experience in the law is more than being a judge. Prosecutors are there. Law teachers on the faculty, they are probably actually oftentimes more current even with developments in the law. You have those who practice in the bar. So there are so many different ways to use your legal training that relying only on those who went to the bench to then elevate them through the system to the top. It's just inbreeding. You are just creating people who have only one experience in the law, and therefore you are losing out on people with a broad diversity of experiences, and you need a judiciary that reflects the diversity of the profession, not just a one-track system, right? So there are all those arguments. For example, on the Supreme Court, they do a lot of constitutional law. That's the only court where you actually do constitutional law. So if you promote people from the High Court through the Court of Appeal to the Supreme Court, you will be promoting people who really have never exercised constitutional jurisdiction. The first time they're going to do it is on the Supreme Court. Meanwhile, somebody has been teaching constitutional law at the law faculty for 20 years. Why do you think that the person who is now going to do constitutional law for the first time is better suited to do that task than somebody who's been teaching and producing constitutional law, a faculty? So there are all those other arguments, and so go and tell the young person.
And then also, with regard to the capping of judges at the Supreme Court, I think also with the recent nominations, the conversations have come up again. And perhaps others have also made that suggestion before the committee that we should place a cap on it. It just has to be an agreement that we will all come to as to what is the appropriate number. The suggestion I got for some of my colleagues was 20. I think it's on the high side. But yes, I don't know what we'll come to, but ultimately there should be a certain cap to it, because if day in, day out, we see how the Constitution can be exploited. There are things that the framers didn't envision. They thought that, okay, we'll all be, pardon? Yes, they thought we'll be very nice. They didn't know that we can be very dangerous. So
we can be human beings.
Yes, so we can be very Ghanaian. So we would all hope that at the end of the day, a certain cap will be agreed on, so we cut out some of the abuses, because we talk about the letter and spirit of the Constitution. A lot of the times we are seeing that we import some spirits that are not there, and the letter is clear, but we see other things. We don't know how. So I hope that we are able to come to something in relation to that. Redwan has already spoken, but he whispered a certain question, something to me, but I didn't hear it clearly. So let me just give him the microphone so he'll say it, okay?
Okay, finally, and I'm very passionate about this, Prof, and I actually hope that the committee would really consider it. This is the issue about sexual assault survivors who have to pay for medical examination. I think it is something that we really need to take seriously as a country, because, of course, the data from the Domestic Violence and Victim Support Unit has shown that a lot of the people who suffer these abuses come from very poor communities where people live on less than $2 a day. And these medical exam fees are around $100. And a lot of people are not able to pay.
Why don't I kick this back to you, right? So, again, let me show you other opportunities that exist outside of the Constitution Review Framework. So now, at least under the current speaker and the previous one, actually, Article 108 has been read to allow private members' bails, so that individuals and groups of people who feel very strongly about a public issue that is not getting addressed in the law can draft, with the help of an MP, whatever, a piece of a bill. You can draft a bill.
Okay, so on that, I did a story in 2022 where I interviewed lawyers.
You should use it, because this is not something that would find a place in the Constitution. That is too specific, right?
Okay.
So there is a way you can find a place for this in the law, current law, by writing just an amendment to the Criminal Offences Act, a particular section, or maybe the Children's Act or something. Find a bunch of people, you do a draft, and you find an MP to champion it and to sponsor it in Parliament, so that this doesn't become the exclusive process for these kinds of issues. It's important, but the Constitution is just one piece of law. There are other laws that can respond more speedily to these kinds of emergencies, right? So I think use that opportunity. It's a big enough issue. If you got a number of champions, if you discuss this with even Amnesty, I think when they presented here, they had some very interesting suggestions on the Constitution's protection of minors in different contexts, right? You could cobble together a coalition, put together a bill like that, and you can find sponsors in Parliament to do this one.
Absolutely.
Yeah,
Thank you
absolutely.
so much.
Sure. Noah, Richard, and back to Kojo, and we will be, it's looking at, we are winding, yes, Gloria, yes. So we'll finish with Gloria.
Okay, thank you, Prof. So I think during the morning session and then even subsequently, there's been comments concerning Section 207 of Act 29 and how it affects the press freedom and the committee doing something about it to protect the press freedom. I just wanted to comment on that briefly, that a lot of times when this issue has come up in the media space, it has been treated as a form of libel and always been related to the criminal libel law, which has been repealed. But when you look at Section 208 carefully, the crime it seeks to address has nothing really to do with libel. It has nothing to do with libel or defamation as we know it under our laws and even as we inherited from the common law. The law tries to draw a distinction between offenses against the peace of the community, which sometimes is called breach of public peace or disturbing public peace, and then laws which are about defamation. Criminal libel deals with those communications that the state may feel is against the reputation of the government and so wants to punish a media person or someone who made that comment. That is clearly unlawful because it restricts free speech. And so that is why criminal libel laws were repealed. But what we find under Section 208 is when you publish a false statement that endangers public peace. That is likely to endanger public peace. So it has nothing to do with defamation or seditious libel or criminal libel per se. And when you look at the 18 U.S. Code Section 35, for instance, it has a very similar provision there, that whoever willfully and maliciously or with reckless disregard for the safety of human life imparts or conveys or causes to be imparted or conveyed false information, knowing the information to be false, concerning an attempt or alleged attempt being made or to be made to do any act which should be a crime prohibited under this chapter. So the idea is that the law that we find at Section 208 has nothing to do with criminal libel or defamation as we understand it to be. Yeah, so it's criminalizing speech that causes a disturbance to public peace, not speech that is defamatory per se.
The problem that is likely to cause. And the question is, who judges the likelihood that it would cause?
Yeah, so Prof, that is where
that is too elastic.
Exactly.
Power to give to the police.
Exactly.
They can come and tell you this is, in our view, as professional law enforcement, this is likely to cause, and it doesn't cause anything.
Yeah, so Prof, my view is that the reason why the argument from the media fails is because they try to bring it under criminal libel, and they would never find space there. Like you suggested there, it is too elastic and subject to a very subjective interpretation by the police. Now, what I have found has been the reason why that practice is being entrenched is that when a journalist is arrested for a comment, like Kweku mentioned, someone made a publication that the president or the president's wife owned certain properties. This does not fall within that ambit of what Section 208 is trying to address.
Sure.
Now, when the person is arrested and the person is released, the matter ends. I believe strongly that on a lot of human rights issues, until we start suing the state agencies that are involved, the practice will become a culture and it will continue as time goes on. So the state controls the police mainly. If there is a government that feels you've made a statement against it that is wrong, the government will come under that to arrest you. The journalist is kept in custody, let's say, for 2 days. He's released, nothing is done about it. And successive governments will do the same thing.
But why do you think people don't sue? Maybe people don't sue because they are also not sure that the suit will survive in court. Yeah. Right? So if you have a jurisprudence that is also very illiberal, right? If you have a jurisprudence coming from the courts that is either illiberal or pro-establishment, then you are also afraid to go to court because you think, well, I mean, maybe they will side with the president, or they'll side with the vice president, or they'll side with the person in power because they feel they feel that they belong to the same kind of class. Say, these media people, they have been talking too much nonsense. And then your lawsuit that you think would open up this thing and liberate now actually generates bad precedent. Now we are all in trouble.
Yeah, Prof, I agree with that, but I think...
So testing the courts is good, but sometimes you create bad precedents for everybody else.
Yeah, I think the challenge is the idea that we will get that law repealed because it's a form of criminal libel. We won't get it repealed because the objective that it is serving to the state is one that is very, very important. And so we may have it amended to make the language more certain, but to repeal it completely, that is a form of seditious libel law, I don't think we will get it. And any journalist who is offended by it, by maybe the state arresting the person, I think that the journalist must go to court. And we are quite skeptical about our courts, but as someone who practices before the court, there are very liberal judges who are taking our human rights jurisprudence to heights that we never envisaged. A typical example is the Tyrone Magai case. No one believed that there will be a high court judge in Ghana who will tell the states that a Rastafarian can go to court with his locks. But there was a judge who did that. And we've been seeing certain judges in the high court who have made statements that in Orbiter, that the state cannot make laws or deal with people who have LGBTQ views in a way that breaches their rights. So there are certain judges in the courts who are very liberal in their thinking and who, if these matters go before them, they will treat it in a way that I think
and I also think it's sometimes even easier. I mean, the lawyers, right? It's not you apply your trade not only in a court. You can also help with drafting amendments to laws, right? One of the biggest challenges with laws that have been on the books for a long time, right? Most of these laws are from 1960s, right? One of the problems with trying to take old laws like that everybody in the legal profession has been used to accepting as normal is that it's very difficult to get somebody who is seasoned, a seasoned jurist, who has been trained on the law, raised on it as if it's part and parcel, second nature to them, to then get up one day and say, all of a sudden it's unconstitutional. You know, when you read a sedition libel decision in 1990, sedition libel case, I think Kumsin and Thompson and no, it's not the Mensa Bonsu case. This is the Kofi Kumsin and Tommy Thompson. You read that judgment, right? And you get a clear sense that the judges were very troubled by that law. And yet, they let it stand. There was one particular judgment that said, yeah, this law, but maybe go to Parliament. And it was being tested for constitutionality. They could have said it's unconstitutional, but they were very nervous trying to get to that point. So I think it's not unusual to find that when you go to court to test certain laws that were done in an illiberal era, and you think that this is a more liberal era, so you get judges who will throw it out. We have all been raised on that law. We learned it in law school. We have practiced it as lawyers and judges. We've used it. So to say that it's unconstitutional all of a sudden one day is not easy to do. So sometimes amendments are probably the best way to deal with it. You know? And so I think we should use multiple tracks because lawyers can draft law too. It's not just litigating. You can draft things. So if you think that maybe the word that is causing the mischief is likely to cause something, draft a law, find a public spirited attorney in Parliament. A lot of people are looking for, you know, fame, and they can champion it. You know, it may be an easier way actually to get some of these laws changed than always going to court with these cases. You know? So I thought I said brother Richard, and then Kojo, and then I think we would end with Gloria will give us the.
Okay, thank you very much. Thank you very much. I'm Richard Ajao from CDG Ghana. So I'd like to first start from where the lady left off on the judiciary. I think in terms of the judiciary, when it comes to the numbers, I think the numbers should be capped at 7. But then it raises the issue of their workload, and I think it's a good argument. So I took time to read parts of the Kenyan Constitution, the 2010 Kenyan Constitution, and I looked at Article 163, 4, 5, and 6, and I realized that they had set some limits on specific cases which should go to the Constitution, to the Supreme Court. So they deal with constitutional cases that they'll raise constitutional issues, cases that are in the general public interest, and then cases that are advisory or they give advisory opinions. I think if it's something that's also set into our constitution, it's going to help with the workload of the Supreme Court, because generally the Supreme Court of Ghana is burdened with so many cases. In terms of the appointment,
have you been a judge on the court before?
no, but I go there sometimes to listen to cases. Based on the appointment, I think our judicial service or our current mode of appointment should be changed. I think first, if we set the number to 7, then positions should be filled when one judge retires. And when a judge retires and there's an empty position, the judicial service should publicly advertise that position. And all persons who meet the criteria based on the current qualifications in the Constitution should apply for this position. Then afterwards, the judicial service should conduct a first round of public interviews, from which they present 3 recommendations to the parliamentary committee, who shall then vet them and provide a report to the House. And then the House, through a secret ballot, elects one candidate to occupy that position. But I think that election...
So voting for judges in the House should be by secret ballot?
Yes, by a secret ballot, by a 2/3 ballot. I mean, it will go a couple of rounds like they do with the Pope, but you want to create a situation whereby majority of the parliamentarians decide on one person. And if it's 1 out of 3, I think there are more candidates for the parliament to choose from.
I mean, supermajority could be like, I've seen other proposals like 60%. It's a lower threshold, but it still forces bipartisanship, right? 75, I mean, 2/3 is what, 75%?
Yes, about 75%. I mean...
3/4 is 75, so it's 66, something,
yes.
something.
I mean, any percentage would be good, but just not a simple majority. I think we should do more than a simple majority to create bipartisanship when it comes to the election of the judges. Then,
first point about number 7, I mean, already we have crossed that threshold, right? So part of the challenge is that we are now in the teens, maybe, I don't know, 15, 16, 17, I don't know how many judges we have. If you cap it at 7, then what do we do? I mean, the current number has long passed 7. Even the current minimum is above 7, right? 9 plus CJ. So if we are already in 16, 17, 18, pushing 20, and you are asking it to be capped at 7, which, if you ask me, is a reasonable number for Ghana, right? Kenya is larger, has a much bigger economy, more litigious, everything. It's 7. But let's say that we already have exceeded that. How do we get it to 7?
So, Prof, and then in the transition, we can, I mean, when you look at the Constitution...
So you deal with the transitional
bit? Yeah, the transitional bit. Yes.
So
in the transitional...
until
we'll have to wait to deal with the current problem. But then I'll also move to something that has really come up actually on X when it comes to political parties, which is campaign and party financing. And it's something that's really important to me. I think our current system is really opaque. Citizens don't know who is donating and how much is being donated. I also, there have been many recommendations. Some people have recommended that the state should fund political parties, and this funding should be done, the allocation should be done proportionally to how the performance of these parties in general elections. Some have also suggested that corporations, political action groups, lobbying groups should not be allowed to donate to candidates and parties.
What is your proposal? We don't have...
So with my recommendations, I recommend that the Electoral Commission or a constitutionally mandated oversight body must have a public database in which persons can access to know who donated and how much was donated. I think transparency is key. Then when it comes to funding for political campaigns, I think that there must be a cap for how much a political candidate and a political party can raise in every electoral cycle or in every financial year. And I think that any party...
How do you ensure, how do you monitor that? I mean, part of the problem we have said is implementation or enforcement. Currently, the law, say, prohibits parties from raising money from non-Ghanaians, for example. It's in the law, right? It's in the Political Parties Act. But we have no way of telling. There's no way of telling the nationality or identity of a particular money source. So the law, some laws are there, right? So on the campaign finance side, if you say, tell us who you raised the money from, they can write all kinds of names. One,
I
right?
think
you can't verify, or you don't have the architecture administratively to even check these things. So in terms of being context sensitive in the regulation, how do we make regulations that work in the context of Ghana? So for example, instead of saying that you should tell us, we should cap how much money you raise. If they hide the money, how are you going to know? But if you said, look, you cannot have more than 7 billboards of this size in any 20-mile radius. That's very easy to police, right? You may not have, no media house can have, no party can have 2 billboards of this size. It's a lot of money. Most of their money goes to billboards and these things. Or you can't have 8 jingles on Joy FM in 24 hours. I mean, so there are certain easy, almost like low-tech ways of making regulation for a society like this place that will ease enforcement and monitoring than creating more law where they are just finding ways to dodge the things and we can't check anything. And that, I think, is part of the challenge we have with implementation. We make laws that require a level of administrative capacity that we don't have and we cannot check. And we are not going to build administrative capacity just to track the identity of who gave a party money. You see, so I think sometimes we have to understand our society, the level of development where it is, and make context-specific regulations that can be enforced just by the eye. I can count the number of billboards of a party and say, no, you have violated the law, right? As opposed to show me the database, where is the money coming from? Where, we can't do it. You know, so I think it's the challenge for the job we're doing partly is this kind of stuff. We're all worried about implementation and enforcement, but the society we are in has to come into view in terms of how do you couch rules that can work. See, so some of these things are for very sophisticated societies. They have the capacity, they have the resources to monitor all of these things. We don't. So it's not that the ideas are not good. It's just the enforcement and implementation issues are critical also.
Prof, just the last one because of time. So it has to be about the members of parliament be allowed to be ministers and board members. I think that's one of the major problems with our constitution because it deals with the issue of separation of powers. And I'm particularly concerned about them being board members because there have been many occasions where these institutions that they are board members of get involved in scandals. And it's not a good look when Parliament, which must then investigate these bodies, have its own members and sometimes senior members of these of Parliament also being chairpersons of these boards. So I think as in a new constitution, it's something that we should look at. I don't think members of Parliament should hold any other position besides being members of Parliament. Thank you very much.
Thank you. They are doing 2-party here. Oh, you also have one. So you can, this is why multiple stations is good for coup d'etat. He makes an announcement, you make your announcement here. So please.
Prof.
Just a couple of minutes. Then
yes, please.
Take his,
good evening. My name is Emmanuel Sapon. I'm a pop culture journalist and also a media personality, but I apply my trade online, so I identify as a new media journalist. For me, my passion is heavily on social media, and I'm sure that's why I was invited to this conversation. In March this year, I think President's Twitter account got caught up, or X account got caught up in some unfortunate hacking activity where it was seen promoting a cryptocurrency. Now, some people obviously haven't seen the post, decided to follow suit and invested some money and lost some money. Yes, the product was Solana. It was, in fact, the confusion was whether it was approved to be posted, because we know the president has handlers who handle social media. But deep down the conversation, the challenge was the conversation had to be centered on, oh, it's his personal account, so he can post anything he wants. So talking to some of my friends, obviously, who have been in the media and, of course, digital media, I think what we came to a serious conclusion over this particular matter was there should be some level of social media policy for our leaders, i.e., presidents, vice presidents, MPs. As it were in the United States, you have Donald Trump having his personal account, but you have the POTUS account. I know for Ghana, we have the Ghana presidency account and whatnot, but it has not been emboldened. And in fact, if you go and check Ghana presidency right now on X, it's not verified. Okay? But time and time again, it's not verified. It doesn't have that silver verification for you to even believe that whatever is coming from there is true. And recently, if I'm not mistaken, I stand to be corrected, I think Ministry of Health or Finance, one of them had to put a disclaimer that an account had been created on TikTok that did not belong to the ministry. So here is a case where that supposed TikTok account was putting out content on behalf of the ministry, and the ministry had no idea about that. And I know it will fall under the cybersecurity space and the Ministry of Information and whatnot, but I just feel like, there should be some level of social media policy that protects some of the information that we receive from our leaders, who obviously gets to the masses through social media, and by way, defeat the conversation that would often come with the confusion of it is his personal account. It's not his personal account, because he can post whatever he wants to put if he chooses. But when you come into office or you come to serve and you are using your account for certain things, people will trust whatever you're putting out there. And if people are falling victim to some of the things like, quote unquote fraudulent cryptocurrency, how do you reconcile that? I think it sows seeds of disaffection and discord amongst the populace. So that's what I want. And of course, the cyberbullying conversation, where we see the future of social media and how trolls have been emboldened on the internet. I know there is a cyberbullying law that protects, but I don't think it has been emboldened or toughened to help with some of these cyberbullying cases. The people who are struggling with depression have to go and deal with mental health issues because somewhere created an account and just decided to troll them or say some disparaging things about them, and they are helpless. They are hopeless because, like my sister rightfully said, sometimes when you go to the courts or the police, you are not receiving that sense of confidence that this particular matter will see some level of judgment. And that is where I would also want to ask, how does the alternative dispute resolution come into play so that we can, allow the courts to handle the huge cases so that some of these matters can be handled from that point of view, because it looks like our courts are getting filled up over and over again. Some cases are being delayed, and so the trust and the confidence in our laws have been reducing because people want to report. They go to the police, they report these matters, but they're not seeing any, if Uko court, I bet check, Ghana court here, already 3 years, 5 years, 7 years, then you do and so on and so forth. So I believe that if you are able to look at how to integrate a social media policy where it protects the citizens at the same time also maintain the freedom of speech that we have in our articles. Thank you.
Thank you. I'll be very brief. There's a particular problem that I believe we can solve while we are, reviewing our constitution, and it has to do with our management and storage of biometric data. Currently, there is no clear direction about which state institution is responsible for the management and storage of biometric data. The NIA Act states that it is part of their mandate, but it doesn't give them the exclusive authority to collect and manage biometric data. This is important because biometric data is such a vital individual marker when it comes to identity. You can be framed if somebody possesses your biometric data. You can find yourself accused of crimes that you didn't commit, and you might struggle to prove your innocence as long as your biometric data is involved. But in our country, we don't have any clarity about who is responsible for collecting and managing it. So today, even though the NIA's Act says that it's part of their mandate, it doesn't stop SNIT from collecting biometric data. It doesn't stop GRA from collecting biometric data. In fact, in the last SIM registration exercise, every telco collected our biometric data. So did NITA. But in spite of all of those collections, we are told today by the new communications minister that we have to register our SIMs again because there is no central database that our info is anchored to. My suggestion is that we solve this problem with our constitution. If we can clearly identify, and for my money, I think the NIA is best placed to be that collector and owner legally of our biometric data, so that all other institutions will simply be referencing their central database in order to identify us at our point of contact. So if I go to the bank and they take my fingerprint, it will be checking it against a nationally controlled biometric database that is managed by the NIA. If I go to SNIT, same situation. Rather than what happens today, when I've even been invited to churches that wanted to collect my biometric data. So that's one. And the other one, this is the one I'll end with. Prof. Karikari talked about how, as we deliberate on how to strengthen our laws around the media, we shouldn't forget advertising. Currently, AI is used across the world for advertising. So there are adverts that we see that were generated by computers, by robots. No human being was involved in the creation of the advert. But that advert is giving us information that we will then probably make decisions based on. So my suggestion is that once again, we make it quite clear in the Constitution who bears the liability. Hopefully the civil liability, not the criminal. Who bears the liability for misinformation, disinformation, no matter who the bearer of the information is, whether the information comes to us through a human journalist or a human social media influencer or AI, that the bearer of the liability should be the platform on which the information is disseminated rather than the individual disseminating the information. So if we can get that clearly stated, I expect that it should solve that problem. And that's it. Thank you.
Mr. Chair, when we are considering the assets of GBC, I'd like to say that I know that when the airwaves were opened up to private investors to come into private broadcasters, I can't remember whether it was a condition, but somehow GBC has a share in almost all the early broadcasters, early private broadcasters. So maybe when we are considering their assets, we may want to look at that and see what it is all about and whether it can be used to the advantage of GBC or not. And then state media, I know that from their IGF, they have a portion that is given to government and then they keep a portion. I think it's 20-80. They maintain 20% and then 80% is given back to government. If we are here, as we are hearing from Prof and maybe the other state media that they have a challenge of funding, is it possible that a law is created for all state media so that they could keep their IGF? Because I know that there are other state organizations that keep their IGF 100% so that they do not rely on government for funding, because after all, the government purse is heavily dependent on and is heavily tasked. And then another thing I'd like to say also is that all media in Ghana, from our opinion, should be regulated, managed by the NMC. We are going digital. Unfortunately, Ghana has delayed so much by 10 years in migrating. Yes, because like Prof said, we should have migrated in 2015. But we are in 2025, and we still have not migrated because that announcement for the shut off of analog broadcasting and the switch on of digital broadcasting has not been made. So technically speaking, we are broadcasting in analog but doing trial phase of digital. So when that happens, at the moment there is talk about the infrastructure is funded by government, and so government has the say to manage the affairs and appoint the board members and all. It is our opinion that it is media. And so for that matter, the NMC should be in charge of appointment to board, managing the entire media in Ghana, regulating and all that comes with media. Then there was also talk about ownership, the ownership of media organizations. I know that in 2017, the Media Foundation for West Africa carried out a research, and they came up with certain recommendations. One of them was the passage of the RTI, which has been done now, so we now have the RTI 2019. And then another recommendation was also for beneficial ownership to be disclosed. I know that the Office of the Registrar of Companies has that in place, so that when companies are registering or re-registering, they are required to provide beneficial ownerships, the names of the various beneficial owners. So I am hoping, and I am sure, that that should cure the lacuna in the ownership of media organizations that we are facing right now.
Is it just the knowing the ownership? Is that the concern that people have, or is it that they are concerned about ownership by a particular class of people, mostly politicians, who they think essentially the whole idea of the media is to police the governance of the country on behalf of citizens, right? That's the model in the Constitution, is that you will have media's responsibility will be to hold government accountable and all of that. And if we have a situation where those who are supposed to be subject to the media's oversight or whatever are the ones owning the media, then that vision is defeated. So the concerns around ownership, I think it's not just that we want to know who owns what, but that we are concerned about a certain class of people owning the media. Is there anything from your side, or is there anything we can do about it?
I agree with what you said, and I do know that the ownership question has to do with a whole lot, both those who are owning and then the kind of people owning. I may be wrong, but I think there's a law somewhere that indicates the kind of organizations or the kind of institutions that can that can own media. And the National Media Commission itself has codes and guidelines for broadcasting along those lines. Maybe we may need to look at all those and all the various policies that the National Media Commission has, and if we need to amend them or anything, that we can deal with that. But by and large, putting the regulation of the media, the entire media space, everything to do with media, in the hands of the National Media Commission, and probably also giving the National Media Commission some form of prosecutorial powers or something, it may help. So that's my submission. Thank you.
Prof. Chair.
Thank you very much.
She
was supposed to be the last person.
Okay. No, I just wonder, because you asked a question about this issue about the ownership, and we are saying that, we're talking about promoting diversity, and we are talking about preventing concentration, as you alluded to earlier on. But above all, we are saying that irrespective of who owns it, the issue of protecting editorial independence is very, very important. Because we see, because of the concentration, the ownership with the political actors or politically exposed people, the editorial independence itself.
How do you really separate the two? I mean, if you allow anybody to own it, so this idea of irrespective of who owns it. That's a big irrespective, right? Because really, if the person who owns it is to be disregarded, and then you say, well, notwithstanding that, editorial autonomy has to be, even the Washington Post, right? Even those places are now having problems, right? The moment, the guy from Bezos or whoever buys Washington Post, certain op-ed pieces cannot be published by Washington Post, and editors have left. So it's difficult to segregate the issue of ownership of the media from editorial content.
No,
right?
so we acknowledge that, but we are saying that, yes, issues about the ownership is very, very crucial. And that's why we are asking for the transparency in terms of the ownership. And even there were issues about even cross-ownership restrictions.
But I'm saying transparency doesn't cure anything.
But that's in addition to the ownership limits that we have proposed, that when it comes to
ownership,
ownership,
you have proposed ownership limits.
But we are saying that when you look at all this, the ownership limitations, the cross-ownership restrictions, the issue of transparency, we are saying that in addition to all these things, what we also want to see is that there should be some sort of requirements or regulations that ensures that ultimately there is that independence in terms of editorial independence, so that they don't unduly influence the editorial independence of the media.
In legislation, this is in your submissions. Okay.
With that, we want to be able to see a certain new kind of media ecosystem where we are not only talking about politics, that we want to understand that before you bring on a media, what sort of ideology are you propagating? So we have examples where people are propagating issues about green or climate change. Some are doing sports, some are doing things about children and something. But it looks like our media ecosystem is populated on just politics. Everybody is doing politics.
Isn't that who we are?
I know, but we have an opportunity to make a change and encourage that people have certain ideology before they are given a certain spectrum authorization. And so that we cure the problem where we are agitating everyone to consume politics.
Even the politicians don't have an ideology.
Content regulation. Thank you.
Even the parties don't have an ideology. You think the media is going to have an ideology? The ideology is cash.
No. Because we haven't gotten, or maybe we never thought about it. Or maybe we did, but we put it on the back burner and we're just going with the free. But we do have an opportunity to make a change or make amends for that matter. So
it's exactly 6 o'clock.
Thank you.
Right? Brother George, you will be 1 second only. No, we will not allow another after this one.
Thank you for allowing me. Last point I want to make. At the end of the day, wherever you see media, money counts. It's about investments, and it's about return on investments, whether it's social or financial. So all the talk about regulation and everything and what has to be done, etc., is fine. But the reality is that GBC has never had the opportunity, for example, to create a myth for us. Look at Don Diego Diaz-Zambuja and King Kwame Nkrumah, right through to Yes and 12 Wars, to everything else, right, about myths, right? Very few people know anything about what has happened in the 40s or 30s, this generation, to do with our politics. Media is supposed to project society, right? And it's supposed to create a society people want to aspire to. That's the power of media. That's what the BBC has done for the English people. That's what the Corporation for Public Broadcasting has done for Americans, right? And where ZDF in Germany, or Al Jazeera for the Arabs. Recently, on the 9th of May last year, Dr. Adesina made a clarion call for an reputable African company, because we don't have a voice on the global stage, right? Our Nancy stories, everything about us is all buried and dead. It's about money, it's about capital. So all this talk about regulation and ownership, it's not important. What's important is, I would say, the Constitution, that there should be room for bold vision, innovation, and technology that advance our course in terms of the power of myth. Thanks.
So that's been a long day, but I think it's been a very productive day. Certainly, in terms of knowledge enhancement for us on the committee, I think this has been a very helpful, very useful engagement. We have learned a whole lot about an industry that we thought we knew something about, but it turns out we didn't know as much. So this has been useful, a lot of interesting input and insights, and we are grateful that you chose to spend essentially your whole day with us, notwithstanding your very busy schedules, and we are grateful for the opportunity to learn from you and to exchange these ideas. So on that note, I think we will bring today's proceedings to a close. Unless any of the members have something to add or say, I think we will call it a day. And Yapong. Thank you.